May I have your lordship's kind leave, my lord, to mention a matter, my lord, I had mentioned on the last occasion. My lord, we have e-filed the section 34 application. There were certain defects. My lord, the e-filing was done within the 120 days under the section 34. After filing, my lord, we have been notified of certain defects. Defects were cured within the vacation period. Now, my lord, after that, now, my lord, on 6th of November, the application has been rejected for e-filing fresh. The difficulty is that, my lord, if I e-file afresh, then the date of e-filing will be beyond the 120 days of, my lord, limitation. Well, that is why I'm seeking leave.
Mention these matters before the court.
But because, my lord, the registrar has already rejected it, and has directed me to again a fresh refile. The difficulty is if I fresh e-file, then, my lord, the registration date will be beyond limitation. So, my lord, the registry has, my lord, asked me to mention before lordships for taking leave, my lord, to refile the matter so that the limitation period can be, my lord.
So I can't do it on a mentioning. Either you move an application or something. How can I do it on mentioning?
But then, my lord, application would have to be in the AP. But unless the AP is registered, then, my lord, any application would, my lord, have no meaning in that.
Find out.
May I hand over this?
The registrar original side, find out how it has to be done.
Lordship, may I leave to mention, my lord, appeal?
So just keep it. Manoj ko rakho.
Lordship, may I leave to mention, my lord, regarding appeal, my lord, which has been challenged, order has been challenged dated 10th June, my lord, of arbitrator, my lord, under section 37(2), my lord, for inclusion, my lord.
Inclusion, don't do it right now. There's a lot of matters right now. We'll see inclusion after 2 weeks.
Lordship.
God bless.
May I have my lord, kind leave, my lord. I want to mention this matter is a section 34 application. Yes. The matter got amicably settled between the parties. I am mentioning for withdrawal of this matter.
May section 34 application where the respondent. I'm mentioning for inclusion. I know, my lord, is
inclusion not right.
Kindly give me one moment to indicate. There was a section 36 filed by the petitioner. They paid the money, got the stay in 2018. Not one step taken by them to have the section 34 ordered out. I got the matter mentioned in the list on several different occasions, but on one count or the other, they come and seek an adjournment. I am not being able to enjoy the fruits of the decree already obtained by me. It is admitted. Sir.
Mention after.
Regarding item number 472, combined list. 472 item number combined list. Execution matter long pending. So
inclusion don't mention right now after 2
weeks. No, that is listed, I am only praying upgradation.
Upgradation can't happen.
Only upgradation.
No, sir, sorry.
Urgent matter,
no
long pending,
no upgradation. We will see it.
Execution.
Let the board move. Let the board move.
May I have your lordship's kind leave to mention, lordship, this is an application for perjury. Lordship, the respondents had relied upon certain forged and fabricated documents.
Let it come whenever it comes.
Lordship, it is running in the list as item number 246 in the month list.
Whenever it has to come, it will.
With your lordship's leave,
Much
if I may mention a matter, my lord, this is a section 34 application. I am for the respondent, my lord. This is a 2015 award, my lord. My lord, the award debtor, my lord, is enjoying a stay on the award.
For some time.
My lord, this is, if I may, my lord, this is listed at item number 157 in the monthly list. My lord, I only pray for an upgradation, my lord.
Sir,
it has been
not right now. Let us see how the list goes. It's just been 1 week. Wait.
Very well. My lord, it was being heard, my lord.
Wait.
Very well.
Just wait. Matters will come up.
Your lordship, 2015.
I totally understand. It will come up. I am also interested in finishing it off. Just wait.
Yes. Your lordship, this is on 37 appeal. The arbitration is ongoing. It's in advanced stage. Your lordship, it's been pending for a long time. Just for
all matters are pending here for the long time. Didn't you hear 2015? Wait for some time.
With your lordship's permission, may I be allowed to mention a matter for upgradation?
Madam, no upgradation right. No upgradation right.
Your lordship, may I be permitted to mention a matter? This is for inclusion in the list.
No inclusion, no upgradation. For 2 weeks, wait.
My lord, I'm praying for your lordship's leave to mention. My lord, this is an upgradation application. Only, my lord, the difficulty that is being faced by me is, my lord, I'm an MSME concern. My lord, an award was passed. My lord, this is an execution petition. My lord, only the issue is the bank is putting up my properties for under surface proceedings, my lord.
That you can't get stalled here.
No, my lord. The issue is the award, my lord. The bank will be able to liquidate their claims.
We'll see that. We'll see.
My lord, may I be permitted to few execution matter for inclusion in the... My lord, this is for withdrawal, my lord.
Withdrawal?
Withdrawal. There's 2 warrant in the matter, that's why. Also.
Call out the list. शाम को बुलाओ तो देखो यहाँ थोड़ी मेंशन होगा. And where is the order of rejection? Registrar has rejected. Where is that? You can't just verbally reject it. It is not.
May I have your lordship's leave to mention a matter?
No, sir. We have called the list. Yes.
One commercial division.
Lordship, this matter has been settled between the parties. It will be withdrawn and there is a warrant, Lordship. Warrant will be discharged.
The matter. Learned counsel for the petitioner states that the matter stands settled between the parties. She wishes to withdraw the present petition. The same is dismissed as withdrawn. All pending applications are disposed of. Only one or
Only 1 and 2.
one and
1 and 2.
one and
Same.
same.
Same account.
Your Lordship, I'm for the award holder. Item number 3. There has been a settlement between the parties. Kindly withdraw the matter. There was an interim order passed.
Same.
Your Lordship, not only 3, 3 to 8. There are 6 matters.
4, 5, 6, 7.
7, 8. There have been settlement between the parties. Kindly withdraw the matter. And there was a interim order was passed.
Interim orders.
Your Lordship, in every matter, I'm filing the statement of the client. Matlab,
Statement of settlement.
yes, withdraw. They are giving the
I
confirmation.
don't really need that.
Okay, Your Lordship, as you wish.
Yes. Item 9.
Lordship, you are directed to attach the bank account details, but the bank account details couldn't be ascertained. So kindly extend 1 week's time. In the meantime, we are filed the supplementary affidavit.
Learned counsel for the petitioner seeks and is granted further 2 weeks' time to furnish bank account details of the respondent. Let this matter be listed after 3 weeks.
Much of list.
Seeks and is granted. Item 10, are you there?
Sir, in 11.
Who's there in?
Then I
Yes.
appear for respondent. A short passover, my lord. My senior.
Who appears for
Miss
the petition?
Soni, for affidavit in opposition, we have to give to this. Miss Soni Ojha is appearing. He is in another court. Kindly give 10 minutes passover, my lord.
Passover.
Grateful.
All passovers will take at 12. Huh?
Blood 11 blood, I appear for the petitioner. The matter is coming blood after service.
Yes.
Blood again, blood after service, blood. They have not come, blood today, blood. I wish to place my application, blood, and whatever the. Are ye dao to judgment sir? Email the service course par ye ache.
What is there in this?
Yes, blood. Your lordship, may kindly, blood, takes. This is the case of blood a joint venture agreement between blood two blood college going students with blood a courier company known by the name Barsana Supply Networks Private Limited. Now, my lord, what has happened, my lord, in between, my lord? The agreement was based that I will invest a sum of rupees 1 lakh as, my lord, equity capital. And, my lord, further investment, say when except above 1 lakh, will be treated as loan to the company. My lord, admittedly, I have made payment of 10 lakhs, my lord, 10 lakh and odd to the my lord, the exact sum is 10 lakh 83,98.
Show me the
Agreement.
initial agreement, yes.
Yes, ma'am. That's at page 23. That is the agreement, my lord. That page 23. That's 13th of May 2025. Your lordship may kindly sees between Barsana Supply Network. That's the respondent number 1. Thereafter, my lord, Pradeep Jha, Sandeep Sinha. That's the respondent number 2 and 3. And my lord, Dipankar Shaw and Dipsankar Shaw are the petitioners.
Dipankar and
Dipsankar Shaw. At page 24, your lordship will find their name. Now, my lord, accordingly, your lordship may kindly turns to very few. Your lordship may kindly first turn to page 35 once. 35 is the clause which provides liability. That's third and fourth party, my lord, are the petitioners. That your lordship will find at page 24. At page 35, the last paragraph, paragraph C, the third and fourth party shall provide an amount of rupees 1 lakh as capital investment for the use of company in its operations relating to engagement of business and logistics and warehousing. Now, my lord, kindly reads this with page 30. Your lordship, under Article 13, which says further fund required by the company. At the bottom, your lordship will find Article 13. Further fund.
13.2. Which one?
13.1, Lord. 13.1. It starts from further.
Further fund.
Transport.
Huh?
Budget transport.
Number Sana supply. Item 11.
Yes, my lord, I have been directed, instructed to appear on behalf of the respondents, my lord. There's a direction to serve a copy.
Give a copy.
Well,
When do you want?
next week, my lord, any day. Because on the operation was.
We have served them through online. Lord.
Give a copy. Now he's appearing.
Oh, number 10, you know. Very well, my lord. We shall serve. Your lordship may kindly takes the affidavit of service on record that we have served. You are appearing for all three or only for?
Yes, I've been instructed, but unless I get the copy, I cannot file the wakalat.
Affidavit of service taken record. Learned counsel for the respondent has entered appearance and states that he has not been served with a copy of the petition. Full stop. Learned counsel for the petitioner undertakes to serve the respondent during the course of the day. Let this matter be listed for further consideration on next week.
Next week,
Next week will my next Monday. In that case,
next Monday.
Grateful, man. Yes. Huh? Time.
But instead of 17th, can it be 18th?
18th.
18th. 18th. Grateful. SH Deve. I don't number 10. Great.
Item 12, I am appearing for the petitioner, Your Lordship. Your Lordship, since this is a Section 29A application, Your Lordship, since the respondents are not appearing in this application, Your Lordship, on the last occasion, we were directed to cause service by paper publication, Your Lordship, which we have done. May I file the affidavit of service, Your Lordship? But I must indicate, Your Lordship, the paper publication which has been annexed to the affidavit of service is from the e-newspaper. If Your Lordship feels, we can come back with the hard copy newspaper. Very well, Your Lordship.
Don't file it then. Come back with the hard copy.
Very well, Your Lordship. Your Lordship, may it be kept after a fortnight, Your Lordship, because I will have to get this paper publication from Madras, Your Lordship.
After a fortnight.
Great.
Learned, just take down. Learned counsel for the petitioner states that he has effected the service through paper publication. Full stop. He seeks and is granted 2 weeks' time to file his affidavit of
personal client. Grateful.
Your Lordships, on item 13, I'm appearing on behalf of the petitioners. Your Lordships, I'm being led by Mr. Banerjee. Your Lordships,
Actually, this
Mr.
is my
Banerjee.
application. Oh, I'm sorry.
Mr. Banerjee is on his legs, Your Lordships. If Your Lordships may kindly allow a short passover.
But may I just indicate this before?
Which Mr. Banerjee?
He's on his legs, Your
Which
Lordships.
Mr. Banerjee?
Oh, Mr. Rohit Banerjee.
It is a 29A application. It's on consent. If my lord so pleases, I can indicate the facts to my lord, because my lord, we are on the end of the arguments. The arguments
Give
are
me the facts. Give me
yes,
the facts. And generally, just give me a one pager so that we can just dictate it.
my lord. It's not even it won't even take me a minute, my lord. This is the third section 29A application.
Yeah, give me the dates. So there's a third application.
Third application, the arguments are concluded. The award is reserved. The
Okay.
arbitrator had a few queries. Thus, the award could not be published. The time period elapsed on 22nd of September 2025.
22nd of September?
2025.
Yes.
The application was affirmed on the 24th of September 2025. The hearing was concluded on 28th of April 2025. My lord will find the minutes at page 123, the last minutes, my lord.
Yes.
The learned sole arbitrator was appointed pursuant to order passed on 20th of May 2022 in application under section 9 of the Arbitration and Conciliation Act. There was a mutual extension of the period in terms of 29A(4) of the Arbitration and Conciliation Act. Thereafter, on 2 occasions, the mandate was extended. Can extend it by my lord, if my lord kindly takes the prayers of my learned friend's application. It is voluminous, my lord. That is why that is why the petitioners have prayed for 6 months. And I am not standing in the way.
Agreement is 2003, right?
Yes, my lord. The agreement is of 20th of July 2003. Lord, I have pleaded that.
Statement of claim.
In paragraph 1, my lord. I mean, it has been pleaded in paragraph 1, my lord.
When was the first extension done?
The first extension, my lord, will find at page 27. It was extended by a period of 8 months. My lord will kindly take the order.
Order dated September 18th, 24.
27th, minute? Yes, I'm sorry, my lord. Internal page 27, petition page 45. I am sorry, my lord. It was by an order dated 18 September 2024. The mandate was extended by a period of 8 months. Thereafter, my lord.
It was expiring at March
Yes.
21st.
All right, take down. The petitioner. The present application has been filed by the petitioner under section 29A of the Arbitration and Conciliation Act 1996, seeking extension of time for conclusion of the arbitral proceeding and publication of the award. Full stop. Learned counsel for the petitioner submits that by an order dated 20th 5, 2022, this court appointed a sole arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed on 18/1/2023. Full stop. Thereafter, with the consent of both the parties, the mandate of the arbitral tribunal was extended by 6 months, up to 20th 7, 2024. Full stop. Subsequently, this court, by order dated 18/9/2024, just see the dates.
Yes, my lord.
18/9/2024, further extended the mandate of the arbitral tribunal by 8 months. Full stop. The matter thereafter reached the stage of final argument, and the mandate of the arbitral tribunal expired on 21st of March 2025. Full stop. Again, while order dated 4/3/2025, this court extended the time period up to 22nd September 2025. Full stop. Learned counsel for the petitioner further submits that the hearing has already concluded and that the award was reserved on 28/4/2025. Full stop. Comma. However, full stop. However, comma, the sole learned arbitrator sought certain clarifications from the party, comma, and thus the award could not be published within the extended period, comma, i.e. on or before 22nd of September 2025, full stop. In view thereof, comma, the present application has been filed seeking further extension of time for the learned sole arbitrator to conclude the proceedings and publish the award, full stop. This is the third application filed by the petitioner seeking extension of the arbitral tribunal, full stop. On earlier occasions, comma, this court had extended the timeline of 8 months and 6 months respectively, full stop. However, comma, considering the fact that the arbitral tribunal has concluded hearings and recorded extensive evidence led by both the parties, comma, this court is satisfied that there has been no undue or unwarranted delay on part of the learned sole arbitrator in concluding the proceedings, full stop. Accordingly, comma, the mandate of the learned sole arbitrator is extended. उससे पहले एक लिख देना, learned counsel for the respondent submits that he has no objection to the mandate being extended further, full stop. Accordingly, comma, the mandate of the for a period of
They've sought for 6 months.
For 3 months from today, full stop. The learned sole arbitrator is requested to ensure that the arbitral proceedings are concluded and the award is published within the time extended, full stop. With the above observation and direction, the present application is disposed.
But by abundant caution, may I seek for 4 months?
4 months. 3 months or 4 months.
In this matter,
Sorry?
Lordship, in this matter, Mr. Parikshit Basu is appearing.
Yes.
He is unable to present today due to
Appear for the petitioner. I appear for the petitioner. Normally, I wouldn't stand in the way to an adjournment being sought. Only one thing here, the arbitration has been proceeding ex parte due to the repeated non-appearance of the respondents. Therefore, out of abundant caution, we've had to file this application because they're also not agreeing to a 6 months extension. They were appearing initially, they had sought to file a statement of defense, and thereafter they stopped appearing completely. Just one order will, the arbitrator has recorded all of this, page 38, page 38, 22nd May 2025. This is the order by which the arbitration was proceeded ex parte. We'll see none of the respondents appears in the appearance. Then page 39, if kindly takes. We'll see that the learned arbitrator records that an advocate for appearing for the respondent had sought time. Thereafter, the fourth paragraph, if I may only place, on each and every occasion, the respondents are trying to get time without any cogent reason, and the matter was adjourned from time to time without any progress. Thereafter, our submissions are recorded. The last paragraph on that page, after considering the facts and circumstances of the case, it appears that from the very beginning, the conduct of the respondents shows that they are not interested to proceed with the matter properly in accordance with the provisions of law, excepting trying to find out a ploy to get time. Hence, in my opinion, the matter should be proceeded ex parte. Thereafter, the arbitrator has proceeded. We filed our affidavit of evidence. Here, the respondents, my humble submission is if sought time over and over again. We kindly extend the mandate. No prejudice will be caused to them if they want to make any.
What is the problem? Are you objecting to this?
Oh, I'm not objecting. Mr. Basu has requested me to seek for an liberty to file an affidavit of opposition.
Oh,
for what?
With the respondent number 4 and 5, I have no objections, my lord, to the prayer sought.
What affidavit in opposition for this?
My lord, I'm requested to seek the liberty. My lord, kindly let this matter be then appeared on any of the day except Friday.
Why are you taking time and time again and again?
My lord, I'm not appearing in this matter. Mr. Parishit Basu is appearing in this matter, and due to
Tell
his
Mr. Basu his conduct doesn't look very encouraging for the court. He could have joined virtually. Why he has not joined virtually?
Lordship, he is due to cold and cough. He is unwell since last Friday. So
We'll have it after 2 days. Wednesday? Not today.
Obliged.
Wednesday.
My lord, may the affidavit of service be kept on record? My lord? If my lord will kindly take it on record, because if my lord, we'll come back on Wednesday. My lord. Obliged.
Minutes, I am for the respondent.
My lord, counsel is appearing online. Mr. Rohitas.
May it please your lordship. My lord, the learned arbitrator was appointed by way of an order of this honorable court under section 11.
Yes. You have any objection?
No, my lord, I don't. Because it is on continuation. First 6 months arbitrator is allowed, my lord, and we are in the respondent in a process
The
of
present application has been filed by the petitioner under section 29A of the Arbitration and Conciliation Act 1996, seeking extension of time for conclusion of the arbitral proceedings and publication of the award. Full stop. Learned counsel for the petitioner submits that the sole arbitrator was appointed by order dated 19/12/2023 by this court. Full stop. The mandate of the arbitral tribunal was further mutually extended by the parties till 10/10/2025. Full stop.
But it will be 10/11/2025. It's expiring today.
10/11/2025. Full stop. The counsel for the party submit that the matter is at the final stage.
Final stage. My lord,
Yes, ma'am.
Final argument stage.
Final arguments, my lord.
Final argument stage. Full stop. In view thereof, the petitioner is seeking extension of the arbitral tribunal, the timeline of the arbitral tribunal by 6 months. Full stop. Learned counsel for the respondent states that he has no objection to the said extension. Full stop. Upon consideration, this court is satisfied that there has been no undue or unwarranted delay on part of the learned sole arbitrator in conducting the proceedings. Full stop. Accordingly, the mandate of the sole arbitrator is extended further for a further period of 6 months from today. Full stop. Learned sole arbitrator is requested to ensure that the arbitral proceedings are concluded and the award is published within the extended time period. Full stop. With the 6 months is fine. 6 months. With the above observation, the present application.
instead of 6 months, maybe 8 months. Instead
8 months.
8 months.
Present petition.
Abundant precaution. It will complete within this post.
Deeply obliged, my lord.
I'm good.
Deeply obliged.
So item 16 and 17, Lordship, my 34 and 36 application, Lordship.
Yes.
Okay. AP 454 is Section 34 application.
My lord, I'm led by Mr. Shatru Banerjee, my lord. Lord, I'm praying for not today, my lord.
Why?
Lord, he is not in court, my lord.
So not today. Please argue. See, these petitions can't linger on for ages. I mean, somebody has to do it. Why you're so? I mean, nobody is ready to argue matters.
Lordship, I will trouble your Lordship to come to page 21, Lordship, para 34. Lordship, my sole defense in this section 34 is that my arbitration application has not been received by me. It is a crushing plant in Bihar. And in this plant, Lordship, we employ time to time any seasonal labor. So one of the seasonal labor has received the award copy and he has not communicated to the proper authority. So we are not aware of the award. We have came to know when the execution application has been filed, Lordship. This is the sole defense that, Lordship, we have been. Lordship, we have tried to pursue this matter to settle this matter. Lordship, talks have been going on, Lordship, but it has
He's
not.
saying talks are not going on.
Lordship, we have tried, Lordship, due to election, Lordship, that I've been told it has been stalled for some time. Lordship, keep it in the monthly list of December, Lordship. Hopefully something positive will come out, Lordship. If
They
it
are
commences,
denying. Last time also you made the statement that settlement talks are going on. They have
Lordship,
said
that is my instructions, Lord.
their instruction is that those settlement talks.
Lordship, this is the scenario, Lordship, that is there. These are the facts, Lordship, that I have been.
So then you argue your matter.
Lordship, then this is, Lordship, page 21, para 34 is my sole defense in the section 34, Lordship. Lordship, may I place it?
Yes.
The petitioner had, Lordship,
page
21, Lordship. AP number 454, Lordship. Of
where is your senior, madam?
My lord, he is not well, my lord. My lord, kindly keep it up after Wednesday, my lord.
Not today. Keep it for Thursday.
Lordship, we commences, Lordship, kindly give fortnight time if, Lordship, something. If,
my lord, no.
They are not agreeing to any settlement talks.
Lordship, fortnight time, Lordship, I don't think much will happen in the fortnight time. Lordship, commences your Lordship, Lord.
My lord, after Wednesday, my lord, then our senior come, then my lord, give the time.
He should have been here if he's so interested in pursuing the matter.
My lord, he is not well, my lord.
Lordship, my humble submission, Lordship, last time, Lordship, can be.
Keep it next week.
Next.
Elections will be over. You settle it if you want to settle it.
Lordship. 17 also, right? Section 36, Lordship. Item 17, next item.
16 and 17 both. No order. At the request of the parties, at the request of the parties, learned counsel for the respondent states that the main arguing counsel is unwell. At the request of the parties, let this matter be listed after 2 weeks. After 2 weeks, let it be after 2 weeks. Let them settle it.
last order টা দিন থ্যাংক ইউ এর আগের অর্ডারটা দিতে বাবা এর আগের অর্ডারটা আপনি পাঠিয়েছিলেন না আগের অর্ডার লাস্ট অর্ডারগুলো তো ডকুমেন্টের ব্রাঞ্চটা মার্কিং করা ছিল কালকে ডাকবো কালকে ঘুরতে চলে আসছে সবাই
Yes.
Yes, madam. For the award holder, madam.
This is my application under section 36(2). More specifically, my lord, I am saying, my lord, this award is an act of fraud. Now, my lord, before I, my lord, proceed, my lord, let me give a gist background of what has happened, my lord, earlier. My lord, I had taken this contention that my clients, my lord, who are the award debtors or judgment debtors before your lordship, my lord, had never signed any development agreement which contains an arbitration clause. Now, this point was taken. Thereafter, my lord, this honorable court was pleased to call for the original records from the arbitrator, my lord, granting us an opportunity to take inspection. Now, my lord, when we took inspection of the documents, my lord, my client possesses the original documents. My lord, it is found out categorically that the original deed as well as the development agreement, my lord, both are forged. So this is my preliminary, my lord, point. Lord, we have also lodged an FIR before the appropriate police station.
Report has come. How do you prove forgery?
Lord, I have found out, my lord.
How?
My lord, because these thumb impressions, my lord, the signatures, my lord, are different.
So you will decide forgery?
No, I will not decide forgery, but my lord, my question is, once, my lord, I have looked into the documents, my lord, I have found out prima facie.
Look into the document, you decide it's forged.
I will not decide, my client will decide, my lord.
Your client will decide.
Because, my lord, my signature is obtained in a paper, it's a forged document, I would not know, my lord. That's the preliminary point, my lord. Now, my lord, why I have taken this point, if your lordship will find out what has happened. My lord, your lordship will find out that there are several parties before your lordship. One is the developer, my lord, one is the finance company, and my lord, we are the landowners. My lord, initially, my lord, a power of attorney was granted in favor of the developer. This is pertaining to a development agreement dated 2002. Subsequently, since, my lord, no development or construction work started, my lord, the power of attorney was revoked. My lord, they run a case that they hold the original title deeds which are mortgaged. My lord, I say that it is not that case because I hold the original title deeds. I have the original development agreement. I have not taken a single pice from the financer. So I have never benefited from the agreement. Now, why I say this is fraud and collusion, because your lordship will find it's only the landowner who is before your lordship. Even in the execution proceedings as well as these proceedings before this court, we have only filed a 34. The original developer who had taken the money, because my learned friends cannot.
Where are the details of the 34 which has been given in the application? Your application details.
The details of?
We have filed 34.
It is pending, my lord. It's recorded, my lord.
No, but where are the details given here,
Just
sir?
for
I
your lordship's
understand that
convenience, but I will take this point. I have the 34 is not appearing in the list. It is not part of the
Not
records.
appearing in the list.
May I hand over a copy of the 34 application?
No, no.
This will be
not
beyond me.
asking that. Where have you stated in your AP number and all the details of the 34 pending before this court? Where has it been stated?
No,
in
both
the
were filed together, my lord. But both were filed together.
But you have to mention it in your application. Where are they?
My lord, usually, my lord, 36(2) and 34 are two separate, my lord, proceedings. My lord, first, my lord, I have to file a 34.
That's the reason why I'm asking you, sir. Because they are separate proceeding. If it was together, I would have not asked you this question.
I believe my learned friend is not correctly instructed because the 34 is of 2023, the 36 is of 2025. They were not filed concurrently.
The 34 was admitted, my lord. They chose to file an opposition. They did not. But thereafter, my lord, the execution proceedings started. Then only, my lord, we filed section 36(2).
Yes.
But, my lord, I believe, my lord, there's no specific mention that a 34 is pending. But it will appear from the, my lord, records of the case. Because 34 is filed long back, my lord.
You should mention it in your application. Please, those.
Lord, what I'm
Facts
seeking
should be
today, my
there.
lord, is to bring these documents on record by way of a supplementary affidavit.
Strong objection to that.
No supplementary affidavit.
But otherwise, my lord, how can I rely on these documents, my lord? But I am running a case, my lord. There is a fraud has been committed, my lord. Kindly have a look at section 30.
Fraud will be looked into by.
But
Your
till
final
such time, my lord, I cannot be executed, my lord. The execution proceedings is pending, my lord. I have a prima facie case to show that, my lord, I have the original title. Let it be verified by the investigating agency.
Deposit the money.
But how can I, my lord? Because I have not taken anything. Kindly appreciates if a single pice has been taken by me, then, my lord, I can be held liable. Lord, I say the very basis. The basis is the power of attorney, by virtue of which they might say that I have said that the property may be mortgaged. Lord, I say that the very basis of the development agreement is bad. The power of attorney is revoked. I have not reached, Lord, I have not taken a single pice, my lord. It's for the developer to pay up, my lord, because he has taken the loan. But developer is not with your lordship, my lord. They are not proceeding against the developer. I cannot be held liable, my lord, because I have not taken anything.
What more?
So that's the basic point, my lord, because if it was a case, my lord, if I say that, my lord, these are all afterthoughts, forged documents, then he has to show, my lord, that I had reaped some pecuniary benefits.
Notice was served upon you. Were you there before the arbitrator?
I was not there before the arbitrator.
Chose not to
My
appear.
lord, no. I
Chose
was
not
no.
to Well, that is why the 34 is very germane. Well, that is the case that he is run in his 34, and that is why it is not mentioned. Well, all these fanciful arguments,
Well,
well,
cannot
kindly
be
say, well,
fanciful.
you will not interrupt me.
Well,
You
I
had
have
your
not
chance.
finished yet.
He did not indicate.
You argue. That's what I asked you. Are you done? You said
No,
yes.
no,
This
no,
is
no.
my
I'm
point.
saying, well, he is interrupting.
No, he's not interrupting. I asked you this question. Are you done? You said yes. This is my argument.
Malad, I say that, Malad, kindly
Make your argument, then we'll
Malad,
hear it.
kindly allow me to put these documents on record, Malad,
Nothing.
until and
I'm
unless
not allowing anything to be put here.
Malad,
No supplementary affidavit. You
kindly have a look at section 36(3), Malad, the proviso, Malad. Kindly have a look. Malad, may I place it once? Otherwise, Malad, I cannot make out my case without there being, because I have to just, Malad, look into these documents. I have to
Show me
serve them to my other side as well.
You're relying on 36(3).
Yes, Malad, kindly have, Malad. Malad, usually in a money decree, Malad, I have to, Malad, secure it in terms of order 41, rule 5.
Yes.
The only exception carved out in the statute is if the award is an act of fraud.
Correct.
Malad, kindly have a look at the proviso. Well, I'm only placing 3.
Yes.
Upon filing of an application under subsection 2 for stay of the operation of the arbitral award, the court may, subject to such conditions that may deem fit, grant stay of the operation of such award for reasons to be recorded in writing, provided that the court shall, considering the application for grant of stay in the case of arbitral award for payment of money, have due regard to the provisions for grant of stay of a money decree under the provisions of the Code of Civil Procedure. Now, comes the proviso. Provided further, where the court is satisfied that a prima facie case is made out, that the arbitration agreement or contract, which is the basis of the award, the making of the award was induced or affected by fraud or corruption, it shall stay the award unconditionally pending disposal of the challenge under section 34 to the award. So if your lordship, Malad, does not give me an opportunity, Malad, to place my 34, which is on merits, and if my 36 is dismissed, Malad, or if I am compelled to put in the money, Malad, then nothing remains. Because I have not taken anything, so how can I pay anything?
All right. Tomorrow, 34 and 36, both together?
Then maybe the day after tomorrow, Malad.
Day after tomorrow, we'll hear 34 and 36.
But Malad, kindly allow me to put this, Malad, on record, Malad,
Nothing
because
on
the
record.
deeds, Malad.
Well, I have a twofold objection, my lord. My learned friend, only when called upon by your lordship, indicated he, and my submission is he chose not to participate. That is the part of his pleading. And all this fanciful submissions of fraud, collusion, they dehorse the ground and the pleadings in his section 34 application. Not a whisper.
That fraud was detected once.
A minute, sir. I heard.
I'm sorry.
No, what?
He should have indicated this. That is the award. He's read the award.
I'll allow you. But
He's
when
read
he
the award.
starts,
He
don't
should have
speak.
indicated this. This dehorses his application under section 34. And my learned friend will kindly, I will request my learned friend to indicate if he reaped the benefits of the development agreement. He has to indicate that before the court. Then I will make a further submission. He says this power of attorney was revoked. We have deeds of 2021 where this developer constructed the building. His clients have sold apartments that the developer has constructed in that building. Deeds as late as 2021 where there is no whisper of the revocation of the power of attorney.
And what is the date when he's saying that the power of attorney has been revoked?
That's in sometime in 2007. And last day, it was this categorical submission of my learned friend that they have not enjoyed the benefits of the agreement. Those deeds I can if he.
No, my lord, if that is so, my lord, I mean very fair, my lord. If that is so, my lord, I'll be out of court because my specific instructions are, my lord, they have not reaped any benefit. If my client has, my lord, lied, my lord, he must face the consequences.
Give him a copy.
That is why, my lord, kindly grants me, my lord, 2-3 days time. I have to ascertain, my lord, whether the deeds, my lord, are on the basis of
objection, my lord. Under section 4 of the Arbitration Act, Lordship is aware of the SQIPO line of judgments that if a party chose not to enter into the arbitral reference, chose not to raise his defense, he is perhaps stopped from raising this point in an application under section 34.
Absolutely.
That will be my first folder submission, that none of these points can be even gone into. Also considering these are not part of his grounds in his application under section 34. But I've handed over a copy of the deed. My learned friend may look into it. The recitals are very clear. I'm grateful, my lord.
Now have a look at it.
Yes, my lord, I'll take in, sir. Can I have it, my lord, on the next week, my lord?
Learned counsel for the
Next week,
petitioner.
but I am in some difficulty.
No, we'll have it this week only.
Yes. But kindly keeps it this week, my lord.
My lord, I need to take in, sir. Maybe on
Take
Thursday, my
instruction.
lord,
These
Thursday.
are registered documents. Your client
You
has
can take
perhaps
instruction
you
in
will
5
not
minutes, sir.
say
We are
this
in the
is
age of
false.
telecom. We are not living in the age of pigeons. You can take instruction in 10 minutes. Your clients are one call away. Day after tomorrow?
My lord, on Thursday, my lord. 34 number to the
Thursday, I have a lot of execution matters.
one day, my lord, it would be a Wednesday, my lord. There was another matter fixed. I said to your lordship, my lord, I am in some personal difficulty.
All right.
That is
Thursday.
my lord.
Great.
Learned counsel the parties. Praise for an adjournment. Let this matter be listed. ये 34 ही मंगा लो इसका. ठीक है. Let both the matters be listed. AP so and so on Thursday.
Also, your lordship, I had
Give the AP
deposited the original documents with the court in a file. They may be presented to your lordship at the time.
Nothing. I'm not recording anything. What original?
No, that is already recorded. Pursuant to directions of this court, I had deposited the original documents.
Oh, that must have been deposited with 34, right?
No, in this application.
In this application.
It was only
Because, my
here
lord,
my learned friend took the point of forgery.
because I'll tell you, lordship, why, my lord, he's saying this, that 34, my lord, I have not taken this point of forgery. My lord, this is what we have subsequently, my lord, understood that the deeds have been forged. The signatures are different, my lord. That is why, my lord, I want to bring into record these documents.
Forget about that. First see these documents. We'll decide both. AP दोनों लगाओ. 36 and 34.
34 আমাকে তো blank copy দিয়েছিস ভাই। Yeah, 211 of 2023.
AP 211 of 2020.
I'm so grateful to your lordship.
लिखे था 211 of, grateful to your lordship. 211 of 2023.
Honored, on the last day, I was trying to argue before your lordship that even though this is my 36-2, I don't have to give any security. That is what I tried to establish before your lordship. Now, lordship, while I was making that submission, I was fully conscious that the order has already been passed in the execution. Means same in 36. Under section 36, the order has already passed against me. Now in 36-2, I am making a further prayer that kindly give stay of this because 34 is also on the list. Now, lordship, kindly see the principle for the stay, which is usually applicable because after the award put into the execution, it takes the texture of a decree.
Yes.
So when a decree can be stayed is also decided in the CPC. Now, if your lordship kindly takes order 43 rule 1. Sub rule 3.
Which order 40?
43 rule order 41 rule 1 sub rule 3. The order টা বের করে রাখি পুরনো order execution order টা বের করো the appellant shall not where the appeal is against a decree for payment of money, the appellant shall, within such time as the appellate court may allow, deposit the amount dispute. So it's not the decretal amount dispute in the appeal or furnish or the second limb of all furnish such security in respect thereof at the cost think fit. So now, so far as the second limb is concerned, it's all is disjunctive, lordship. This or is disjunctive. So, moment the second limb is concerned, now, lordship, we have to see what order lordship has already passed in section 36. I'm in 36-2. So, lordship, kindly see in 36 what order has been passed. if your lordship kindly takes up the order passed not in my application, but in the execution application of 19 September 2025.
এক্সিকিউশন শুক্রবার দিন ছিল লিস্ট
ও তাহলে ওটা আজকে নেই, তাহলে অর্ডারের কপি দাও।
আছে ফাইলে আছে দেখুন বার করে দিই
আসে দাও।
আছে
None appear on behalf of the award debtor. It is informed that the award debtor has challenged the award and then received the application for stay for the award. The award was approximately 1.8 crore. Under such circumstances, the award shall ensure that at least a balance of such maintained in its bank account for a period of 3 months or until further order in the application filed for, or until the further order in application filed for the stay. So, Lordship, what is the thing? So, security is already there now.
So let that be extended.
Yes, this will be extended, of course. I am not on that way. Lordship will extend. But Lordship, what they said, that I have to withdraw the entire money, I have to deposit here, that is not the case here, Lordship. Since he has obtained that order.
That is the intent of the order.
No.
It is securing you. You secure it here.
With deepest
intent of the order.
Lordship, then money is coming out from one account, which is under Ministry of Finance, is got back to the another bank, which is also under the same Ministry of Finance. So, Lordship, if your Lordship so desires, because my bank account is not Mr. X bank account that it will be, it might have been siphoned or something. My every money is under the CAG. By the CAG audit, my money I keep. So, Lordship, kindly see. Once this order they have obtained under 36, can they go beyond this in 36(2)? And when there is no complaint that I have ever tried to violate this. There is
36(2) is you who has filed.
36. We both come under 36. He has come under 36 with some provisions that executed. I have come under 36. Please stay it because my 34 is pending. So we all under 36. Now in 36, the order has been passed. 36, the security has been taken. Now this principle of order 41 rule 3 is also talks about the security. Now he is having a security. Now he has never complained of that security. That no, I have some way interfere with the order. That is also not his case. Then can we rethink the issue for a new security for the matter? This is only I was submitting this.
Your Lordship, this mindset that the public corporations will have a privilege was specifically dealt with by the Supreme Court in the case of Toyo Engineering, where Your Lordship Lordship, it's a short order. I'll just place it. Leave granted. We have heard Mr. Such and Such, learned senior advocate, appearing on behalf of the appellants, and Mr. Such and Such appearing on behalf of the respondent. This court repeatedly having held that Order 41, Rule 5 principles are to be followed in these cases. We find that largely because public corporations are involved, discretion continues to be exercised not on principles under Order 41, Rule 5, but only because large amounts exist and the government corporations have to pay these amounts under arbitral awards. Both these considerations are irrelevant, as has been pointed out by us earlier. As a matter of fact, the very matter referred to in the order dated such and such has resulted in a dismissal of Section 34 in an award that was granted out of one of 17 other contracts arising out of the same transaction. Mr. Such and Such at the pains to point out that Section 34 was dismissed in that matter on completely different grounds. Be that as it may, such and such at the highest therefore would be relevant. This such and such appears to be the main plank on which an amount of rupees 125 crores alone was ordered to be deposited out of an awarded amount of 662 crores. Resultantly, we set aside both the orders and require 100% deposit of the awarded amount to be made within a period of 6 weeks from today. The appellants may apply to the High Court to withdraw such amount on security. So, Your Lordship, this argument that I will have to take it out from one bank account, which is the Ministry of Finance, and again deposit it. Your Lordship, 36(2) does not differentiate between a public corporation and any other person. Your Lordship, this argument was specifically dealt with, and here it was set aside and asked them to deposit the 100% of the amount. Because if Your Lordship will kindly appreciate if it is not done, Your Lordship, I am not in a position to offer any counter guarantee and withdraw that money. Your Lordship,
this exercise, he will bear interest even in his account. Even if he secures before your lordship, he will also get that interest, whoever wins the matter ultimately. So lordship, this argument subject to what falls from your lordship is not the public corporation, not a privileged litigant who will have to be treated differently under law.
Yes. Lordship, the question of privilege as a PSU, I did not work. What I say is, first is, here the section 34 has lost. So the court has scrutinized the thing. After it was a private litigation, the court has scrutinized and 34. My case is completely different. Lordship is, I'm in Lordship's hand and 34 is there before your Lordship. It's in the list. First. Second. Now, Lordship, the second part of it, Lordship, if I keep it to the bank, why I'm so resistant to it? So, Lordship, the interest which is given to me, I have to pay. And if I put it to my another hand, same Ministry of Finance, Lordship, that gives me, say, 8%. 8% is the interest. And in FD, I will get 5.5 or something as a corporate. Now, Lordship, this 2% or 2.5% on 2 crores will come on me. So I am hesitant. Instead, if your Lordship, this money is secured. Lordship, I will file an affidavit to that effect. I will give a bank statement every month that I am keeping that money there. But Lordship, if your Lordship takes out my money and give it to my next brother to hold it, and Lordship, then in that issue, the technicalities will take my 2% of the amount and which I have to pay from the government exchange. And then Lordship, whether he will take out the money or he will not take out the money.
If we take your argument, sir,
yes,
then in all the matters,
yes,
no money will be kept as a security deposit. Everything will be in your account only. The courts will stop passing directions if we take this argument.
If someone has the ability to freeze his money to the decretal amount, then yes, that's why it is said the security in other form. That is the intent of Order 41, the second leave. Why it is done so? Lordship, why it is done so? Because in the execution stage, court do not wish to proceed and attach property and sale, and this exercise is need not to be done under what is to be done under section 21. Now, Lordship, if you Lordship kindly see this, my order in a private litigation has not even tested today by a court. If your Lordship kindly asks me that, yes, if your Lordship kindly freeze that amount to that extent, or Lordship, that security, Lordship can take security of my corporate house. Lordship, keep that another attachment. Security does not mean that I have to give the enter into cash security. I have my assets. If your Lordship, my asset is there within your Lordship's jurisdiction, 6 lands range. My house is there. Any property of mine is more than 100 crores. So Lordship can attach one property of mine. But if your Lordship take out that, then Lordship, I will be suffering 2.5%. Lordship is a security. Lordship wants a security that I will not go away with his 1.8 crore rupee. So Lordship, the security, because since I am a solvent company, I am a government company, it is easier to take the money in a form of a security. Lordship, take my assets under security. I will offer one asset as my security. I have housed my Middleton.
For which your Lordship, then I'll have to learn to pillar to post to get it executed.
So he wants to make, that's the thing. He wants to make his execution very clear because I am a government company. Now he wants to take advantage of being a government cash-rich government company. He wants to take advantage of my situation. He wants security. I am giving security, Lordship. What he wants is exactly in 21, he should not face any hindrance. Moment he wins 34 or 37, he will take away.
That is the intent of the act.
No, that is not. The intent of the act is not to make someone's execution easier. The intent of the act is so that someone should not make the degree infructuous or unexecuted. So you have to see in every respect whether I have any effort or I have any intention to make the decree unexecutable. This is not the case. There is a difference between unexecutable and making something easy to execute. So the cash security is actually making a private person to make the execution easy. And here, Supreme Court has taken a stand because the corporation, Indian Oil Corporation, fought his litigation up to 34 and lost it. So at least one court. So whenever I say that the arbitrator has done this or arbitrator has violated or absolute bias, at least one judicial eye has looked into it. That was the thing. Now, in my case, it's a complete award before your lordship. Second thing is, lordship, I am giving security. It's not like that I'm saying I'm running away from the security. My money is attached in the bank. In addition to that, lordship, I will give a property. My bank account to the extent of 1.8 crore is attached. It's not the case that I have made the balance below that. I am saying give additional security of a property. So you can deduct my bank account, and now entire corporation will have only one bank account, because now the business account cannot be at 10. Now we have only one centralized bank account from peon to chairman, or everyone is being paid from that. So lordship, kindly see. So my bank account is attached. Lordship can attach my bank account and take back money if lordship wants to make his execution easier. But today, lordship, if lordship says that no, even I will not attach the bank account, I will not take a property with it.
This is not the first award which is being passed against national insurance, right? Show me the law. Show me the law where the court has indulged and said, you can keep the money in your account. There is no need.
No, it's not a keep the money in the account, lordship. I bow down before your lordship. It's not like that I'm holding my money back.
You're an insurance company.
Lordship is...
You're facing this day in, day out.
I never endeavored to, because I never got opportunity of attachment and this. Most of the time we face 36 after 34. So then I become defenseless. Here we got a chance, lordship, honestly. I got a chance where 34 is alive, where security to the extent of attachment is there. And then I am offering my additional security of my properties. So lordship, kindly see, even in case of execution against railways, lordship, the general manager's office had to be attached. That has happened. We have done this. So here, I am only on a small part. One security is there. My bank account is already attached. So now, my learned friend is arguing, no, that is not. You take out from your bank and keep it. I said, don't take out. Let it be there. I will keep that maintained. And additional security of one of my property I am giving. So lordship, if that is not bona fide, only in a particular way taking out money and giving deposit, if your lordship so wants that in which cases properties are being taken into account and given a security. Because end of the lordship, kindly see, if we fail, suppose I have failed in 34 dismissed, lordship is only hearing 36. Lordship, what lordship will do? Lordship will first do affidavit of assets. Then lordship will look into what asset is in lordship's jurisdiction. Because I have an asset at Chennai, lordship will not be able to sell a property at Chennai. So that for that execution will go to the local court of Chennai. So lordship will take my affidavit of assets. Lordship, the first thing lordship will attach my immovable property. But only because I am a cash-rich government company, this will be taken out from my account. This argument was not made previously by any of our panel lawyer before your lordship. Today I am saying. So lordship, if we...
I have always seen your innovative arguments even on the other bench also, Mr. Which is good. There's always something more to add to it, which is...
Says not good.
Your argument is making
that sound.
Making metallic sound. Here also, metallic sound.
So lordship, today we have to stand and we have to come back. Lordship, that in a very easier way, always we corporations say, yes, take that, we are cash rich. And we try to convince our client, what is the use keeping in your money, or it is high court's account money here. Same interest you will get. We try to convince our clients, lordship, most of the time. Because no one takes the pain to stand by and say, no, this is incorrect. This is prejudice to my client's interest. Lordship, we have not argued. Trust me, lordship. But lordship, today lordship has to see that main money is attached. Principal amount is attached. Lordship will In 21, Lordship will go by the affidavit of service, affidavit of assets. And Lordship will first attach my property, which is Lordship's jurisdiction, and which is 5 lands range. So, Lordship, in that case, will your Lordship ask me to suffer that 2.5%? And if so, then why, Lordship? I put this question to myself. Why every time we will? We are suffering a degree. It's not like that it's a felony we have done. We done a commerce. Sir, what happened? I have given a insurance coverage to someone. He purchased a insurance coverage of 40,000. He took first in the same year. First, he took 1 crore from me because of one devastation. Second, again, he lodged a complaint I did not give, but he got another 1 crore. So, Lordship, I made a business with him with the 40,000. I am giving him twice. Forget. These are aspects in the 34 I will ask, Lordship. I will try to explain that in 34. But Lordship, can you see the tenor of the 34 even? A man, it's not an award that where a trading has done. It's an insurance coverage. We have to also keep it in mind. Suppose I have done a trading with Dan, someone has invested on me 30 crores, then I have not paid the money, then he gets 5 crores as a difference or 2 crores as a difference.
I take the insurance cover more seriously, Mr. Bennett.
Yes. Yes, but the same man in the same go down, I will take your Lordship to 34.
More than the commercial
Seriously, insurance coverage, seriously, yes. But whether most of the cases, insurance claim, how far they are very honest claim, Lordship, we will also look it into 34 because I have 34. I will show your Lordship there. So, Lordship, today, Lordship, the scenario before your Lordship is a not why I am saying is not a trading, Lordship. Because had it been trading, then he invested something, he is not getting money, something is blocked, his investment is blocked. I should allow to deposit the cash security so that his business can run. Now here he suffered a loss has been quantified by someone, then Lordship with damage he got that money. He attached that money in my one account. And then Lordship this. Now Lordship, I leave it to your Lordship with this argument. Now Lordship decide what should I do.
Which is subject to correction. The nature of the dispute has nothing to do with the securing under section 36. And also what my learned friend is asking that I will suffer financial, I'll suffer 2.5% is not for consideration under section 36. 36, the intent of the award is if you, in the act is, if you have an award in your favor, you are entitled to get it secured so that you can, if you want to stay in the decree. So the intent of the award is, intent of the section is to secure the amount. Whether he suffers a loss of 2.5%, your Lordship, that even if I lose, that also will go back to him. Whatever, your Lordship, the financial aspect is not relevant in this aspect. Your Lordship, those are my submissions.
All right, take that. The petitioner has filed the present petition under section 36(2). 36(a)(2). of the Arbitration and Conciliation Act 1996, seeking a restraint order against the implementation and operation of the arbitral award dated 28/4/2023, passed by the learned sole arbitrator. Full stop. By the award, the learned sole arbitrator awarded a sum of rupees 1,74,74,396. Right? That's the amount. In favor of the respondent and directed that in the event of failure to release the said amount within a period of 3 months, the same shall carry a further interest at the rate of rupees 6% per annum until realization. Learned counsel for the petitioner states that the petitioner has already secured the said amount by keeping it in a separate bank account. You have secured it by keeping it in a separate account for the...
That I am not having the instruction. Same account, Lordship can say.
Learned counsel for the petitioner states that he has kept the amount secured, and since the petitioner is what are you? What do we call a public sector undertaking? with a robust financial health. He states that he states that he shall not deposit the said amount with this court, and that the said amount can always be realized from the petitioner. Learned counsel for the respondent states that the intent of the act.
No, Lordship, I have taken 2 more points, Lordship. I said that I can offer a immovable
counsel
property
for
as a
the
security.
petitioner.
Lordship, this will make his execution easier. That was not the intent.
Learned counsel for the petitioner also states that the petitioner is ready to.
No, I'm not ready. I'm said court may direct me to do so, and I'm in that case.
You are suggesting this.
Yes, I'm
Learned
suggesting
counsel
in
for the
view of
petitioner
order
suggests that he can also put one of his properties before the court to secure
property within jurisdiction.
Property within jurisdiction to secure the interest of the respondent in claiming his awarded amount. Full stop.
And Lordship, that 41 second.
Learned counsel for the petitioner further relies on Order 41, Rule 3 to impress upon the said argument.
Order 41, sub-rule, Rule 1. Order 41.
Order 41, Rule 3, you said.
Rule, sub-rule 3.
Rule 1, sub-rule 3. To impress upon this argument. Full stop. Anything else? Learned counsel for the respondent states that the intent of the act under section 36(2) is to secure the awarded amount, and the petitioner shall deposit the said amount to secure his interest. Full stop.
Lordship, kindly record that prejudice will be there on my 2%.
Learned counsel for the petitioner states that since he is a public sector undertaking and the amount being put with the bank to secure the award will prejudice him by losing interest on the said amount.
Differential interest.
Same thing, sir. Differential interest. Differential interest also. Same thing. Full stop. Learned counsel for the petitioner further submits that the award has already been challenged by the petitioner under section 34 of the Arbitration and Conciliation Act 1996 by filing AP Com number. What is the number?
Lordship, I'll just write it down.
Yes, Lordship, I have mentioned it.
I'll just see that. AP Com number 361 of 2024, old number 603 of 2023, which is pending adjudication. Full stop. However, the respondent initiated execution proceeding EC number 434 of 2024 for enforcement of the said award. Full stop. In view thereof, the petitioner has prayed for stay of the operation of the impugned award dated 28/4/2023. Full stop. 28/4/2023. Full stop. This court has heard the submission of the submissions of the counsels. Full stop. And has produced the materials on record. Full stop. It is evident that the learned sole arbitrator has passed the impugned award after affording opportunity of hearing to both the parties, and that the petitioner has actively participated in the arbitrable proceedings. Full stop. No grounds of irregularity or denial of opportunity was made at the stage of arbitral proceedings. Full stop. However, considering that the award is already under challenge before this court under section 36 of the Arbitration and Conciliation Act 1996, and in order to balance the equities and safeguarding the interest of both the parties regarding execution and operation of the award dated 28/4/2023, this court stays the operation of the impugned order subject to the condition that the petitioner shall deposit the entire awarded amount along with awarded interest before the Registrar General of this court within a period of 4 weeks from today, full stop. Upon such deposit being made, comma, the Registrar General is directed to invest the said amount in an interest-bearing FDR with auto renewal facility to be maintained until the disposal of
In a nationalized bank, kind.
with a nationalized bank until the disposal of the AP Com 361 of 2024 and filed under Section 34 of the Arbitration and Conciliation Act. Full stop. It is made clear that in the event of failure on the part of the petitioner to deposit the said amount within the stipulated period, comma, the interim protection granted under this order shall automatically stands vacated without further reference to the court. Full stop. In such an event, the respondent shall be at liberty to proceed with the execution proceedings in accordance with law. Full stop. With the above direction, the present petition stands disposed of.
Well, I'm appearing on behalf of the respondent. Before my learned friend begins, my lord, I'll be seeking a 10 days adjournment.
Why?
My lord, I need to file an execute and wakalatnama. And because, my lord, the respondent's son is critically ill, has been admitted, my lord. It'll take some time to, my lord.
Ship, this is my application under section 36(2) and I want to secure the amount.
documents also. My lord, kindly urgency for 10 days, my lord.
But if they filed an execution petition in Haryana, I want to secure the money here under section 36(2) so that, Your Lordship, the execution is at least stayed. Thereafter, Your Lordship, it's a medical ground. I cannot.
That's what. We'll keep it after 10 days. 10 days?
10 days.
Not today. We'll keep it after 10 days.
Grateful, Lordship.
My lord, appearing for the award holder, in the previous order, it was directed upon the award daters to file supplementary affidavit of asset. We have not been served yet.
The award debtors, my lord. But by an order dated 23rd of September, my lord, a direction was given, my lord, to file a supplementary affidavit to bring on record, my lord, certain additional document with respect to assets, my lord. Since the, my lord, the award debtors reside in Orissa, my lord, we are taking, my lord, we required some time, my lord, to, my lord. We have already brought, my lord, the assets, my lord, we are supplementary affidavit is, my lord, ready. But we're in the process of, my lord, filing of the supplementary affidavit, affirming and we will file, my lord. But some time, my lord.
Yeah, we've already taken so much time. Why
Lord,
more time?
Actually, ensuing vacation, my lord. 1 week time, my lord, I will.
Learned counsel for the award debtor seeks and is granted further 2 weeks. 2 weeks time to file a supplementary affidavit of asset as directed by this court by order dated 23rd September 2025. Stop. List after 3 weeks. April Thursday then.
Well, my section 34.
Yes, Mr. Singh.
Well, the point is somewhat, but it is a point of jurisdiction. Why I say this, my lord, I will not take too much of your lordship's time on this. Kindly have a look at the application. But it is a matter which has now come.
Let us hear the entire thing.
Well, this was
So
filed
only
in
if
the
your lordship.
commercial division.
No. Let me take 2 minutes of your lordship's time. Kindly have a look at the application, which is on record. AP, the main 34.
Yes. I have it.
Kindly see at the top what it says.
Transferred under order dated.
Yes.
3/8/2025.
That is honest. if it has been, it cannot have been transferred under section 15. When is the court having a jurisdiction to transfer? Lordship will first see the cause title. It is filed as per the petition in the ordinary original civil jurisdiction. Kindly have a look at that is first. Second, your Lordship will kindly come to paragraph 53 at page 44 of the petition. Commercial Codes Act bar kore rakho 15 ta. Third sentence from the top. The said cause of action arose within the jurisdiction of this honorable court. This honorable court has the jurisdiction to determine. So, their petition's case is that the ordinary original jurisdiction of the court is the court to determine to.
Where are you reading? Page 44, para?
Just the top paragraph, my lord. First 3 lines from the top.
They said cause of action.
Said cause of action arose within the jurisdiction of this honorable court,
Here and determined.
and this honorable court has the jurisdiction. So, as per the petition originally filed pre-transfer, it is the case of the petitioner that ordinary original civil jurisdiction is attracted. And they have invoked the jurisdiction of the original side of this court. Kindly have a look at the filing date. It is post the notification of constitution of the commercial division of this court. Must have been filed sometimes in 2020. 5th February 2020. So this is also a fact that it is admittedly beyond the date of the notification constituting the commercial division. Now kindly have a look at section 15 of the Commercial Codes Act. Not only that, Manal, I also, before I take your lordship to one more, kindly see the first order passed in this matter. That is of 10th of February 2020. 10th February 2020. Well, I'll hand over a copy of the order, Manal. Yes, well, I have the bunch of orders. This is the order of 10th of February.
I have.
Yes. Kindly see, matter appeared in the cause list in the original side. AP number 74, not registered as a commercial matter. The court has exercised jurisdiction on 10th of February in the original division. Accordingly, application AP 74/2020 is admitted. So the admission of the 34 application is by the honorable judge exercising ordinary original jurisdiction. Now kindly have a look at section 15, my lord. Now the Commercial Codes Act.
Yes.
Transfer of pending cases,
Also.
which means that on the date of the notification constituting the commercial division, if the cases are pending, which are having commercial subject matter and of specified value, all suits and applications, including application under Arbitration Act 1996 relating to a commercial dispute of a specified value pending in a high court, where commercial division has been constituted, shall be transferred to the commercial division. So the power has been given to transfer only matters pending as on the date of the notification. This application was not pending on the date of the notification, admittedly. Now, my lord, I just show the judgment of our court. This issue arose whether the court can transfer proceedings admittedly of commercial subject matter filed subsequently in the commercial non-commercial division. Kindly have a look at Lakshmi qualifier. Yeah. Kindly have a look at Got it. Paragraph 73, your lordship will kindly go.
Automation.
Lakshmi qualified AI at 21 Calcutta 190. Kindly see para 73, my lord. Despite the absence of power under section 15(1) of the Act of 2015 to transfer a suit to relating to a commercial dispute of a specified value in the ordinary original civil jurisdiction of the High Court, having a commercial division, to the commercial division of such court after such suit being filed subsequent to the specification of the specified value, the court has power under Order 7 Rule 10 to deal with the same. Powers under Order 7 Rule 10 of the Code of Civil Procedure stands regulated by Section 15(1) of the Act of 2015 so far as pending suits relating to a commercial dispute of the specified value in the ordinary original civil jurisdiction of the High Court. Once the suit has been filed beyond date of notification of the specified value, Order 7 Rule 10 of the Code of Civil Procedure will govern the field, not Section 15. Now kindly come to paragraph 79. I'll kindly come to 76 also once. A suit. Now this is under 15. What happens in case of 15? A suit transferred under provision of 15 has to be considered as continuation of the old suit now to be tried under commercial division or in the commercial court as the case may be. However, a suit involving a commercial dispute and of the specified value filed subsequent to the notification of the specified value has to be transferred to the commercial court or the commercial division as the case may be under the provisions of Order 7 Rule 11 of the Code of Civil Procedure. Such suit, when presented before the commercial court, has to be treated as a fresh suit in view of the ratio laid down in such and such. Now 79, which relates to Arbitration Act. So far as proceedings governed by Arbitration and Conciliation Act involving a commercial dispute within the meaning of Act of 2015 are concerned, they would be guided by Section 15 of the Act of 2015 for filing up to the notification of the specified value. Filings in the courts other than commercial division would mean that such filings have to be transferred under Order 7 Rule 10 of the Code of Civil Procedure if such court is invited by any of the parties to the proceeding to do so or dismiss it under Order 7 Rule 11 of the Code of Civil Procedure. In case of a proceeding on act on the rights of 12A are not attracted. So therefore, even court has no suo motu power to return it unless the party approaches the court. If it has to be done suo motu, Order 7 Rule 11, it has to be dismissed. This is the stand of the Calcutta High Court, subject to correction. I know this has got the stamp of approval of the this is the position which is now prevailing. Now, I show your lordship, why I say that from the petition as originally filed, it shall be deemed to have been filed in a non-commercial division. Because of the pleadings in a commercial suit or in a commercial application.
I'll be back in
10
minutes so that she can brief Mr. Saha.
Saha is here.
No, I'm sorry, my
Yes, Mr. Sen.
My lord, insofar as the test of determining, my lord, whether the petition as filed is a commercial or not, the averments and the pleadings is essentially to be considered. This has been clarified, my lord, in Ambalal Sarabhai case, my lord. Because, my lord, the commercial suit will essentially require the plaintiff's statement why it is commercial, that it falls within the subject matter of commercial. Well, that your lordship will kindly see paragraph 9 of the judgment.
So what will be the fate if you are saying that it has been filed on the original non-commercial jurisdiction, though at that point of time the commercial jurisdiction was already in existence, and the transfer has not taken place. So what would be the fate?
Order 7 Rule 11.
At best, my lord, at best return to be filed afresh.
Unless
Not rejection.
No, that is the line here. Unless the parties approach. Here they are contesting. They are saying, no, whatever is there is correct. So there is no approach.
No, but they are acting. They are not saying that. They are acting on the order of the court. The 10th February, not 10th February, the order which had been passed by Justice Bhattacharya. That is the order on which they are acting. They are saying that it has been changed to the commercial jurisdiction. So they are well within.
No, kindly see 25th July order. They are praying for, they have prayed here for transfer to the commercial division.
No, my lord, transfer from the list, my lord, to the original, to the commercial list, my lord, not to the division, because the court holds that it has been filed in the commercial division.
Kindly see, my lord.
So, my lord, I can't, my lord, ask for transfer from the original, from the commercial division if it has been filed in the commercial division.
So
it is transferred to the list.
Very well. So my stand is that there is no approach by the other side saying, please return it. They are still contesting that it has been filed in the commercial division.
That is what the report also says. The report of the registrar also says.
That is what I am saying, my lord. What does the report say? Report says on what basis? Kindly read that, my lord. It says, because of the presentation form and the endorsement in the ledger. There are two things which the report is saying as ground for concluding that it is on the commercial side. They are saying the presentation form of the petitioner and the entry in the ledger. Presentation form is not signed by the petitioner. It is not part of the petition. I am showing your lordship the petition. Averments in the petition. Affidavit in the petition. The petitioner has invoked the jurisdiction of the original side, original division. And therefore, my lord, kindly here, my lord, the Ambalal Sarabhai will come into play. It is not the petitioner's case on affidavit that the subject matter of dispute is a commercial dispute. Claim is above the specified value. Therefore, the Honorable High Court in its commercial division has the jurisdiction. I have shown your lordship the paragraph of the petition. They themselves have invoked the jurisdiction of the ordinary original side of this court on the basis of the usual pleadings as is there. So, my lord, it is the registrar's report on the face of it is contrary to the petition. Registrar's report, my lord, cannot be sacrosanct. Your lordship will have to see what the petition is. Today, my lord, kindly consider this. Your lordship was taking up corporation matters. If there is a presentation form in a petition which says it is a corporation filed in the corporation jurisdiction, subject matter, your lordship finds out it is a land matter, what would be the effect of the order? Same thing here. The registrar is saying that it is filed. I have put it as a commercial matter because presentation form says commercial. I am showing your lordship the petition. The subject matter is non-commercial according to the petitioner. Therefore, my lord, the registrar's report is not sacrosanct. I could have understood registrar applying in my mind and saying that the petition in substance is commercial and they have invoked the commercial jurisdiction. So, my lord, I say, my lord, relying on the principle laid down in Ambalal Sarabhai, but I'll just place one paragraph 9 of that judgment, my lord. Just kindly take one at paragraph 9. Further, at page 591.
Yes.
Further, on referring to the cause of action in para 21, the plaintiff has thereafter referred in para 2 to the jurisdiction of the court to hear and decide the matter. It would be appropriate to extract the same like in our case. Even though in the paragraph describing jurisdiction, plaintiff has stated with regard to territorial since the office and land wing, there is no reference indicating the reason for which the plaintiff pleads that the court, which is the commercial court exclusively constituted to try the commercial disputes, has jurisdiction to try the instant suit. In that background, a perusal of the prayer made in the plaintiff indicates suit is one seeking specific performance in terms of MOU, whereunder it is agreed that mortgage deed, even if the immovable property under mortgage deed was the subject matter, it was necessary to plead and indicate that same was being used in trade or commerce, due to which jurisdiction of the commercial court is invoked. Without such basic pleading in the plaint, any explanation sought to be put forward would lead to a situation if an objection is raised in every suit, a consideration would be required based on extraneous material even to ascertain whether the intended transaction is to be construed as a commercial. So basic thing is that if it is a commercial plaint, their necessary pleadings to say that it is a commercial dispute has to be in the plaint itself. Here it was a case whether the averments in the plaint would show that it was a commercial dispute or not. Court said no, the pleading is otherwise, and it will not come under property used exclusively for trade or commerce. So based on the pleading which stands in the plaint, the classification is to be done. Here I am saying, well, their pleading is that it is an ordinary suit. They have filed it in the ordinary court. There is no question of transfer of this after the notification. And since they are themselves are not praying for having it taken back, then, my lord, your lordship's power is only under Order 7, Rule 11. That is, my lord, what has been clarified by our court. I think, my lord, only thing, my lord, that report has been filed. I have given an exception to that on this basis. That no, correct. Very, very well. There is also, my lord, one guideline which has come subsequently, however, which has said what is the form of the pleading. I'll kindly take this. This has come in 2023, notified in 2023.
Volume?
Kindly see rule para 6, form of pleadings. Kindly see 6.1. These are the requirements. In our case, it will be E, aggregate value of the claim if any of the specified value and above. Then, my lord, what is important is 9.4. In the event of a suit or other proceeding which is barred in terms of clause 9.1 above, if neither party applies for the plaint or application to be written, the court shall reject the plaint or application, as the case may be. These are my submissions.
So dealing with the last contention first. Well, if neither party applies, then it will be rejected. Now, the question of applying would arise only, my lord, when there is acceptance of the fact that it has been filed in the wrong division. Now, my lord, our contention it has been filed in the commercial division. My learned friends contend that no, it has not been filed in the commercial division, but although it should be filed in the commercial division. Now, my lord, in this case, Well, since my lord, our assertion before the court is, and my lord, that is backed up by the registrar's report and by the order of my lord, one of the learned judges of the coordinate bench order of 25th July 2023, that it has been filed, my lord, correctly. My lord, there is no question of my asking for, my lord, return or transfer. So, my lord, I would be, my lord, really stopping myself, my lord, from raising this contention that I am now, my lord, advancing before your lordship. If I, my lord, say that no, please return the petition and, my lord, let it be filed afresh. Now, my lord, comes the question of pleading. Well, your lordship is considering a section 34 application. Well, the foundational pleading of any section 34 application is the pleading filed before the arbitrator. Well, here, my lord, the pleading is, my lord, in the form of a statement of claim. The statement of claim, my lord, which is a part of, my lord, the petition before your lordship, if your lordship sees it, clearly talks about a, my lord, construction contract. Now, if it is a construction contract and the tribunal has returned a finding on a construction contract, where it has accepted part of my claims and rejected a part of my claims, then, my lord, will my learned friend, my lord, now be entitled to canvass a case that, look, in the section 34 petition, you have not stated that these are the ingredients of a commercial, my lord, contract, which have now found place in the section 34 matter, and hence, my lord, must receive your lordship's attention, my lord, as a, my lord, original matter filed without a, my lord, commercial division, my lord, nomenclature, because, my lord, you have not made pleadings. Now, my lord, when we talk about plaints, well, your lordships have held, my lord, times without number, that when you're looking at a plaint, it is not only the plaint, but the documents annexed to the plaint and the documents referred to in the plaint. So, my lord, when considering an aspect of, my lord, rejection of plaint, Order 7, Rule 11 say, your lordship looks at the plaint, the documents annexed to the plaint, the documents referred in the plaint. Now, if your lordship finds from the documents annexed to and referred in the plaint, which would include in this case, my lord, the statement of claim, that is, my lord, in every facet, a commercial contract, then, my lord, is it open to my learned friend to say that no, confine your attention in an isolated fashion only to the section 34 application, look for pleadings. If you don't find pleadings which says that this is a commercial dispute, then you reject the petition. Well, Lord, that is essentially my learned friend's contention. Now, my lord, apart from everything else that my learned friend has shown, well, if your lordship will kindly see, well, Lord, this was a notification of my lord, our High Court. Well, Lord, may I just hand it up to your lordship? I'll give my learned friend a copy. Well, this is published on, my lord, 8th of February 2024. Now, my lord, this is what it records. It is notified for all concerned that after the promulgation of the Calcutta High Court Practice Direction Rule of 2021 and pursuant to the direction of the Honorable Chief Justice High Court at Calcutta, it has now required to convert, well, this is important, it's now required to convert old pending case of Commercial Court Division and Commercial Appellate Court Division in the CTS for smooth functioning of the court and publication of cause list. During such conversion process in the CIS, the old number of the pending matter shall be converted to auto-generate new number for the year 2024. Now, my lord, pausing here, my lord, what is to be, my lord, numbered afresh? My lord, filed, my lord, in the commercial division with an old number to be now converted. Now, my lord, if your lordship will kindly turn the page, my lord, this is the list. If your lordship sees at the top of the next page.
Yes.
List of cases converted from old nomenclature to new nomenclature according to High Court of Calcutta Commercial Courts Practice 2021. And now your lordship will again turn the page. Your lordship will find serial number 23 is this item. 83, I'm sorry, not 23. Forgive me. 83. My lord, this is, my lord, the old number, which is now, my lord, converted in the new number. It was previously numbered in the commercial division as AP 74 of 2020. It is now, my lord, AP Com 181 of 2024. Now, my lord, the department of the court has now, my lord, marked it AP Com 181 of 2024. It would not have happened if it was not filed as a commercial matter in the first instance. So, my lord, my learned friend's arguments are, my lord, really misplaced. My lord, and your lordship will kindly see this also comes with the filing date. It was filed as a commercial, my lord, matter on 5th February 2020 with only AP 74 of 2020 number. My lord, converted on 12th February 2024 with AP Com 181 of 2024. Now, my lord, if I have filed it correctly, the department has numbered it, my lord, correctly according to what was the prevailing practice of the department. The department has suo motu, my lord, numbered it afresh as a, my lord, commercial division matter. Then, my lord, how can I be faulted? And my learned friend wants to, my lord, get rid of my application by seeking a rejection on the ground that it is incorrectly filed in the wrong division. Of course, it is a jurisdictional question. If I have not, my lord, invoked, but also, my lord, there are, my lord, judgments now which says that it is really a part of the same High Court. It is really transfer from one department to the other. Division bench judgment of our court, which says that you can't reject it. It has to really form the practice of Order 7, Rule 10, and my lord, there has to be a transfer. But my lord, we need not go there. That would be only, my lord, if one accepts the fact that it is filed in the wrong division. My lord, here, my lord, the department registry says it's filed correctly. The department says it's filed correctly. The court records it's filed correctly. But then, my lord, how do I now, my lord, accept the fact that, my lord, I filed it in the wrong department? And, my lord, my learned friend's argument that one has to look at the pleadings. If you have to look at the pleadings, please look at the pleadings of, my lord, the underlying, my lord, contract, which is, my lord, the statement of claim. That clearly shows it's a construction contract. Cannot be in any other division but the commercial division. Well, this is, my lord, the short, my lord, submission on this aspect of the matter. Once we overcome this, we can go on to the main matter.
No, I think, Mr. Sen, we should go on the merit of the matter.
Very well.
We'll deal with your, contention as far as the submissions are concerned, but let us hear the main matter.
The only request is, my lord, there's a fixed matter. May I come back tomorrow? I'll argue the matter.
Next week,
I don't mind, but I'm, my lord, a little inconvenienced today because there's a matter fixed, my lord, in which it's a continuing part of the matter.
Okay. Then kindly keep it next week, my lord.
Next week.
Next week.
Apart from the 18th and 19th, my lord, 18th, 19th, I'm in difficulty. Any other day?
Yeah. Mrs. Saha, 18th, 19th.
18th, 19th, I'm in difficulty, my lord. Professional difficulty, of course.
So what about 17th?
Yes.
The award of is of which year? This one?
Well, award of
2020.
2020.
2019, 21st November 2019.
Was it
21st November 2019.
We'll start hearing it. We'll see. At the request of the parties, let this matter be listed on 17th?
Yes, ma'am.
17th.
Great. Very good.
इसको रख देना मनोज. ये Gopal.
Lordship, I am appearing on behalf of the award holder, and on 23rd September 2025 order dated, this court has given direction to file award debtors to file their affidavit of assets within 2 weeks. But they are not filed yet any affidavit of assets. Currently issue a fresh warrant against award debtor number 1.
My lordship, I am appearing for the judgment debtor, my lordship. The affidavit of assets has already been afforded, my lordship. Kindly give only 2 days, my lordship, for effect the service upon the award holder, my lordship.
Lordship, affidavit of services indicates that the service affected upon the award debtors.
Sorry?
Affidavit of services completed and the services.
My lordship, I am only seeking for the service of the affidavit of assets, my lordship.
You're appearing for?
My lordship, I am appearing for the judgment debtor, my lordship.
All, how many judgment debtors are there? One?
2 judgment debtor, but judgment debtor 2.
Just take down. Learned counsel for the respondent has entered appearance on behalf of the judgment debtor. He states that the affidavit of asset has been affirmed. He seeks and is granted 1 week time to file his affidavit of asset with advance copy to the counsel for the petitioner. Let this matter be listed. Give a date. Any Thursday. Any Thursday, give it any Thursday.
Services.
Affidavit of service taken on record, just like
24 is some matter.
same.
Same.
23, 24, same step record. Award debtors may be different, right? Or the same award debtors also.
Two award debtors.
Two award debtors, my lordship. Great, your lordship. First one matter, item number 10.
Lordship, I appear on behalf of the petitioner, Your Lordship. They have given their opposition, Your Lordship. We have to file the reply, Your Lordship. Kindly gives us 2 weeks' time.
May I file my opposition?
What application is this? 34?
Section 9, Lordship, yes.
Affidavit in opposition filed by the respondent is taken on record. Learned counsel for the petitioner seeks and is granted 2 weeks.
Yes, Your Lordship.
2 weeks time to file a
Great.
reply to the affidavit in opposition. List after 4 weeks.
Grateful, Your Lordship.
कहाँ चलेंगे? 7.
Item number 70.
Well, I am for the petitioner in this matter, my lord. This is an application for setting aside the award, my lord. I am filing this affidavit of service, my lord. Very old matter, my lord. Your lordship can direct me to fresh serve again them. And they are not appearing, my lord.
What is of which year?
Of the 24, the year 2024. 30th March 2024, my lord. My 2 grounds are there. There was no notice was there. And unilateral arbitrator was appointed. This was the award, ex-party award.
Please take down. The present petition has been filed under Section 34 of the Arbitration and Conciliation Act, seeking setting aside of the award. What is the date of the award?
30th March 2024.
30th March 2024.
Gulab Rao, Vaman Rao, and some arbitrator, name of the arbitrator.
None appears for the affidavit of service taken on record. None appears for the despite service. None appears for the respondent. The respondents are directed to file their affidavit in opposition within a period of 4 weeks. Reply to the same, if any, within 2 weeks thereafter. Learned counsel for the petitioner undertakes to serve the copy of the order on the respondent.
Within 3 weeks,
Rest of 6. After 6 weeks.
I'm good. 6 weeks. Pradeep Kumar likhe dega.
#71, my lord, I am for the respondent. My senior will be
Your Lordship, I beg to appear for the respondent in this matter.
So this has become infructuous, the section 34, because this is from an interim award. Now the final award has been passed by the arbitrator. So this has really become infructuous in that sense.
Why it has become infructuous?
Why I say so? Because Your Lordship, there was an interim award granted for the entire amount in my favor initially under 31(6), because it was found that the respondent had no defense. Now, since the respondent had a counter claim in this matter, the arbitrator directed that the counter claim should be deducted from the main claim and the balance claim should be given to me. Now, in the final award, the arbitrator has held that the respondent does not have a valid counter claim, so the counter claim has been rejected and the entire amount has been awarded. So this was the earlier stage. So
The
that's why it has...
arbitrator is sitting here, Mr. Sen.
Yes, Mr. Sen is sitting here. His award is under challenge. So he has already allowed the entire claim in my favor. And by rejecting the counter claim, that's why it has become infructuous.
So that is the reason they are not coming.
Yes, might be the reason. That's why they're not coming. Right. The award, Your Lordship, is 25th of April 2024, and the final award has been passed on 26th of August 2025.
I'll simply dismiss in default then.
Yes, Your Lordship will do.
It's not recording anything. None for the petition. The present petition is dismissed for default.
Grateful.
Your Lordship, for item number 72, I have been instructed by the advocate on record who is appearing for the appellant in this matter. Your Lordship, who is unwell, I am praying for a note this week.
My lord, Aparna Banerjee, advocate for respondent number 2. She is also not in the court because her mother-in-law expired last night.
Not
so
this week.
After 18, my lord, please.
After 18th.
Thank you.
Grateful, Lord.
Grateful, my lord.
Yes, a client record ka lena usme learned counsel for the petitioner states that the main arguing counsel is indisposed. Learned counsel for the respondent number 2 states that there's a bereavement in the family and both the parties praise for a short adjournment. Let this matter be listed after.
My Lord, 73 is a post-award Section 9 application, my Lord, filed by the award holder. My Lord, similarly, Section 5 is also a Section 9 post-award. My Lord, Section 7, serial number 74 and 76 are Section 34 applications which have been taken out by the award debtor. My Lord, the pleadings are complete in the Section 34 applications. And my Lord,
It can be heard out.
it can be heard out, my Lord. Section 9 application, my Lord, this was filed in September 2024. My Lord, no affidavits have been filed. So I'm guessing, my Lord, my learned friends won't file an affidavit. So, my Lord,
If Lordship is hearing the 34.
Let's hear the 34.
So everything will be
Then
decided in
everything
the
goes.
34 itself. Either it stays or it does not stay. If it stays, he will execute. No post out.
9 becomes infructuous.
Yes, 9 will become infructuous.
Yes. So how many are connected matters, Mr. Sen?
This is
73 to 76.
Yes, but the section 34 is 74.
And 76.
74 and 76.
So the others are the application which are connected to the 34, right? So it will take care of all these matters, right?
Yes, yes.
73, 74, 75, 76.
73 and 75, your Lordship can say that these are post-award section 9 since the 34 is being heard. Those may not, can be disposed of as...
And 76 is what?
76 is another 34.
Another
2 awards, will it?
My Lord, 2 awards of the same day, 7 December 2010. Same nature of contract, my Lord, 74 and 76 are Section 34 applications.
So 73 and 75, your Lordship can say since the matters 34 are being heard, nothing will remain.
No, my lord, I will request your lordship to kindly not do that because, my lord, 2010, my lord, award is passed. My lord, 2011, the section 34 applications.
Not passing any orders on
Right.
your. Just let's hear the.
The contract is page 38 and 45. Similar contracts, two contracts. Jute Corporation of India, my lord, they are the seller, we are the buyer. These contains the clauses, my lord.
These must be old. The award is of which year?
2010.
2010, my lord. So, my lord, their nominee arbitrator.
Yes.
The two issues, my lord, which will arise here is whether, my lord, the tribunal has assessed.
So the contract is of which year? This is
Contract is of
2006.
2006.
What are the terms of the contract?
Lordship will kindly come to page 38. This is the contract by way of exchange of letter. Kindly see two measures PEC Limited. This is the buyer.
Yes.
In fact, this is the agent of. Yes. This is the agent of the petitioner. My client. Jute Corporation of India is offering to me for purchasing this. Now, my lord, kindly see. Clause 4.3 at page 40. This relates to the security deposit clause.
In the event of failure to deposit requisite amount of the 4.3.
4.3.
In 30 days from the intervention.
In the event of failure to deposit requisite amount of security deposit within 30 days from the date of issuance of the offer, offer shall be deemed to be withdrawn. Then, my lord,
4.7 is also there, which is damages.
4.6 and 4.7 is their right to recover carrying charges, incidental charges
PCI reserves the right. Jute
of
Corporation.
at 2% of the contracted value or 25 per quintal will from the security deposit in the event of failure of buyer to submit a valid LC within period of 5 days.
From the security deposit.
4.7 is the important clause which will come here for consideration as the damages. Right to recover carrying charge and other incidental charge at the rate of 2% or 25, whichever from the security deposit in the event of the failure of the buyer to leave the contracted amount of jute within 30 days from the date of submission. JCI reserve the right to forfeit the entire amount of security in the event of buyer failing to leave the entire contracted amount within the period of 60 days from the date of submission of the LC. Then paragraph 6 is the terms of the LC. Well, I am not going into that because the question is, only question here which will arise is, I have cancelled the contract. The buyer has cancelled the contract. Whether the cancellation is right or wrong. If the cancellation is wrong, then has the seller proved the loss suffered so as to be entitled to claim damages? This is the ultimate question which has to be decided by the tribunal. Your lordship will have to see whether that question has been decided in accordance with law or not.
That your cancellation of the contract.
My cancellation of the contract, whether
that has caused financial.
Whether it amounts to a breach. First of all, is whether it amounts to a breach. If it amounts to a breach, they are not automatically entitled. Principle of section 73 of the Contract Act comes. So, have they proved sufferance of loss so as to be entitled to claim damages under section 73? These are the two issues, which will arise. Now, your lordship, kindly see clause 12 at page 43. This is their right. Under the contract, this right of cancellation is given to Jute Corporation.
Yes.
In the event of
Sorry, which page?
This is page 43, clause 12.
Yes.
In the event of any delay or failure on the part of the buyer in making payment arrangement as specified herein within 30 days from the commencement of the contract and or his or her failure or refusal to take delivery of the contracted quantity within a period of 60 days or to perform any of the terms of the contract, corporation shall have the right to exercise these options. So this is a right of cancellation under the contract.
But this on the ground of
On them. They are having the right.
Yes, on the ground of your failure.
Yes, on the ground of failure. Kindly, then we have the arbitration clause, your lordship. Arbitrator other than an employee of the seller to be appointed by the chairman cum managing director. These kind of clauses are now not enforceable. Yes.
That's a different law now.
That's a different thing, my lord. Now kindly come to, my lord, page 52.
Yes.
Jute Corporation is writing to SB Overseas. This is in reference to the following contracts in respect of your 5 mill companies which are still pending. Poranagar, Agorpara, Premium Agro. So this is Premium Agro, we are concerned with this. We have from time to time, I'm sorry, my lord, before this letter, your lordship will kindly first take this document at page 59. Yes, page 59. 7 September 2006.
The total of home.
In the sequence of event, my lord, this is the first document will come first. This SB Overseas is writing to Jute Corporation. Please refer to our discussions wherein we have booked a total of 40,000 quintals raw jute from various centers as mentioned in earlier. We are giving below the allocation for various mills. Premium Agro 1800 and 1350. And the other one, the other matter is Agorpara Jute Mill Limited, that is 2800 and 2100. These are the two companies in whose favor the contracts are being entered into for these allotted quantities. Please arrange to send your contract in favor of PEC Limited on account of the above jute mills separately so that arrangement of opening of letter of credit will be completed soon. In the meantime, we are enclosing herewith our check amounting to 35 lakh being the security deposit until such time the bank guarantee and LC on account of individual mills are opened in your favor. Check shall be returned as soon as the LCs and bank guarantees are received. So this is the document showing the furnishing of the security deposit under the contract. Now kindly note November 22, 2006 at page 60. This is our coming from SB Overseas, that is from us. Kindly see the subject. The fourth one is regarding premium, that is this matter, and the fifth one is the contract relating to Agorpara.
Yes.
We are saying, please be informed that due to financial crunch, we will not be able to make any further payment against the above contracts. And as such, balance quantity may be treated as cancelled without any market difference. We find that there remains some balance out of 35 lakhs paid to you and adjusting the deliveries made by you recently. such you are requested to deliver the balance quantity in any of our mills against the balance remaining with you out of 35 lakhs paid to you. So we are saying whatever is remaining out of the 35 lakh security deposit, that should be adjusted towards the supplies. No further supplies of in excess of 35 lakhs we are in a position to take. So before the goods are made ready for delivery or appropriated to us, we are intimating that we are not going to take delivery. So it is not a case of breach. We are surrendering the contract. We are saying 35 lakhs is with you, deduct security deposit, whatever supplies you have made to us, also deduct, and the balance which remains, the deliveries must be made commensurate to that. I am not making a promise that you give delivery, I will make additional payment. So the transaction should be closed as on November 22, 2006 on the basis of the balance which is there. This is my categoric stand. Now kindly see thereafter. Next, kindly see a further letter we have given on July 4, 2007 at page 61. Each 25th June 2007. Kindly come to page 52 thereafter. After page 60, kindly come to page 52. They are alleging non-compliance here. They are saying this is in reference to the following contracts in respect to your 5 mill companies which are still pending. Kindly see regarding Premium Agro, they are saying quantity delivered, balance quantity for which payment arrangement to be made 3152. We have time to time requested you to arrange for necessary payment arrangement, take delivery of balance quantity, but you failed to make payment arrangement for lifting of raw jute as per contract terms. You have further requested via your letter dated November 22nd, 2006 to cancel balance quantity. You are unable to make payment arrangement due to your financial crunch, which is not acceptable. There was a jute mill strike from January 5, 2007 to 8th March, and you could have made payment arrangement after the jute mill strike was over, which you have failed. We request you to make immediate payment. This letter we have replied at page 61. In this, we are in receipt of your letter dated 25th June 2007. Surprised to note that you are showing balance quantity of 37,700 against the so-called contract FS5 and FS6. 37,700 কোথায় দেখাচ্ছে? Yes, total is 37,000 or all mills.
All mills.
We are only on Premium and Agorpara. Premium, they are showing balance quantity 3152. In this connection, we refer our letter dated 13 September, which is that page 60 letter, wherein we have requested you to send a sample quantity against our advance payment of 35 lakhs. And if it was also mentioned, if the quality is approved, then we may negotiate for the entire quantity of so-called FS5 and FS6. Further, we also refer our letter dated 22nd November, where we have categorically said that due to certain unavoidable circumstance, financial, we are not in a position for taking any further quantity. We have also mentioned that contracts sent to us and accepted and signed inadvertently may please be treated as cancelled, as there was no price difference as on 22nd November 2006. Thus, we requested you to cancel the balance quantity without market difference. Moreover, it is surprising to know that there was no correspondence on this issue. since our last letter of 22nd November 2006, and all of a sudden after 6 months you have raised the issue by letter 25th. It is a closed matter. We are not at all liable for any further delivery against free sales contract. After this, my lord, they have kindly come to page 56.
This is same letter, two contracts.
This is their advocate's letter to take the balance quantity, alleging that I did not have any authority to cancel. Cancellation is bad. Either I take the balance quantity, or kindly see, my lord, the second page of the letter at page 57. Although you were under an obligation to deposit security in spite of repeated requests, you have failed and are neglected to deposit the same. You have also not furnished payment arrangement for 31 lakhs for contractual quantity of 1800 quintal. Though our client asked you to take delivery of contract by making payment arrangement, the aforesaid contract authorized our client to terminate if you fail and neglected to comply with the terms and conditions, but there is no clause authorizing you to terminate the contract in question. In the premises, unilateral termination on the ground is contrary to the terms and conditions of the contract. Our client, by their writing dated 25th June to the requested you to take delivery of the contractual quantity after making payment for the same. Otherwise, necessary action would be taken as per the terms of the contract. In spite of receipt of the letter, you have failed and neglected to take the aforesaid quantity. So this is the advocate's notice. We have given a reply to that, but it is no point we're not placing that. I'll show your lordship first what is their statement of claim. What is their prayer? If your lordship sees the statement of claim, it starts at page 65. There are identical statement of claim for the two contracts. If your lordship takes one, it will cover the other as well. 65 is the first one, and 78 is the other one. Kindly see the prayer at page 75. Before I show your lordship the prayer, kindly see the basic pleading in the statement of claim, which is very essential insofar as the claim of damages is concerned. First is, my lord, kindly come to paragraph 15 at page 72, where they are pleading the breach. Yes, just, my lord, before that, I may just show your lordship, my lord, paragraph
71,
page 71, para 9 and 10. Subsequently, respondents by writing requested JCI to adjust aforesaid deposit of 35 lakhs proportionately against the value of raw jute to be delivered in respect of all the 5 mills mentioned in the preceding paragraph. As per the request of the respondent, JCI has adjusted from the aforesaid depositor sum of rupees 7 lakh out of total jute value of 26.40 lakh, being the total jute value of contracted raw jute to be supplied to Premium Agro. So, security deposit is admittedly given,
Yes.
and that has been adjusted. Respondents had taken delivery of raw jute equivalent to 7 lakh, and JCI had adjusted the said sum against the aforesaid deposit of 35 lakhs made by the respondent. Subsequently, JCI asked respondent to take delivery of the balance contractual quantity of jute by making payment arrangement.
After lunch?
Yes. Your lordship is taking
That's what I'm-
commercial after lunch.
ये after lunch तो नहीं हो पाएगा. Non-commercial है. बस एक वो And then I'm hearing a matter also from the other roster.
I see.
I want to finish it off. We'll have it then tomorrow we can try.
Wednesday, Thursday execution है.
Thursday execution.
Thursday execution.
So he will do it first. He will take time. Let's continue it. Otherwise, the delay then.
I will come with the judgments. That is why I want 1 day.
All right, then.
Wednesday, your lordship will keep it. We'll do it. Yes.
Matter heard. Let it be listed on Wednesday. Combine कर दो ना इसको. I'm just combining all the matters. Matter heard, listed on Wednesday. 73 to 7. Okay. Yes.
May I continue?
But just one matter. There's a
Very well.
I appear for the award holder. I am for the my lord, award holder number 3, my lord. On the last occasion on 3rd of November, some of the award holder was arrested and surrendered. At that point of time, we undertook that the award holder number 3 will surrender. Today he has surrendered before this honorable court, my lord, and undertakes to file the affidavit of asset by the next day, my lord. It is fixed on 24th of November, my lord.
क्या नाम है आपका?
अभय कुमार राय।
पैसे क्यों नहीं दे रहे हैं?
सर देंगे, क्यों नहीं देंगे?
हाँ,
कोर्ट का आदेश होगा तो दे देंगे।
बिल्कुल कोर्ट का आदेश है,
ठीक
पैसे
है सर,
दीजिए।
दे देंगे सर।
गिव हिम ओथ।
मैं
मैं
गवाही के तौर पर
गवाही के तौर पर
जो कुछ बोलूंगा
सच बोलूंगा,
सच बोलूंगा,
सच के सिवाय
झूठ नहीं बोलूंगा,
झूठ नहीं बोलूंगा,
कुछ नहीं छुपाऊंगा।
कुछ नहीं छुपाऊंगा।
आपका नाम बताइए।
अभय कुमार राय।
ए
ए भी
वाई कुमार राय। पिताजी का नाम
श्री राजनाथ राय।
राजनाथ राय। अरे भाई, आपका उम्र
92 जन्म
92
19
30+। आप क्या करते हैं?
अभी तो सर कुछ नहीं कर रहे हैं।
अनएम्प्लॉयड। आपका घर का एड्रेस बताइए।
अभी सर जहाँ है वहाँ का
परमानेंट एड्रेस
27/1
27/1
SC घोषियन
घोष
पाइकपाड़ा।
EM पाइकपाड़ा। पाइकपाड़ा कौन सा?
मध्यस्वर पोस्ट पोस्ट पोस्ट
पाइकपाड़ा
हुगली में।
हुगली।
The award number 3,
नहीं आएंगे तो अरेस्ट कर लेंगे।
Abhay Kumar Ray, has been arrested by the police and produced before this court. Full stop. The oath has been duly administered to him. The award
He surrendered.
yes. He has been brought or surrendered?
Surrendered.
Oh, yes, surrendered. No change. The award number 3, so and so, has surrendered before the court. Oath has been administered to him. Full stop. The award undertakes to furnish his affidavit of asset and further undertakes to appear before this court whenever required. Full stop. Learned counsel appearing for the award number 3 submits that the affidavit of asset shall be filed
And by the next date, my lord, 24th.
24th, my lord, your lordship has already given that date.
fixed that.
before the next date of hearing. Accordingly, on such submission and undertaking, award number 3 shall be released from the custody. Full stop. Accordingly, the warrant of arrest stands discharged. Next date, 24th. 24th.
Grateful.
24th लिखा हुआ है। इसमें डेट तो 24th लिखा हुआ है। थर्सडे ओनली, तो ये सब मैटर थर्सडे ही आएगा। ठीक।
Item 3 is for withdrawal of Section 34 application if it can be taken up before the part heard matters. Item 3, my lord. Item 3 of the today's non-commercial list. My other side is also there.
Item 3 ले लो। Non-commercial list में item 3 कॉल कर लो।
3.
Item 3.
We seek to withdraw the Section 34 application, my lord. This is the copy of the board resolution. Let it be on
Sit down.
record, my lord.
Learned counsel for the petitioner seeks to withdraw the present petition. The same is dismissed as withdrawn. Full stop. A copy of the instruction received from his client is taken on record. Full stop. Respondent का भी appearance mark कर देना.
Deeply oppressed.
Dismissal withdrawn.
Well, may I proceed, my lord?
Yes. So what has been argued by Mr. Banerjee is that 232B.
Well, I am not on 232B.
Okay.
Well, I am challenging the validity of section 179 2D as amended by the KMC Amendment Act 2022. But I believe a number of authorities have been cited by Mr. Banerjee. Well, I will not repeat.
But he didn't cite number 10, which he left it for you.
Yes. but my lord, some of the, but only couple of authorities I would like to cite in a greater detail. My lord, I will be, well, the period in dispute, if your lordship so pleases kindly, period in dispute is from 1984-85 to 99-2000 fourth quarter.
99 fourth quarter.
99-2000 fourth quarter. But the here the assessments are made, the bills are raised every quarter. So my lord, 1984-85 first quarter, right? First quarter till 99-2000 fourth quarter. The assessment were exactly made on 16th November 1999. Thereafter, my lord, the assessments were sought to be challenged before the Municipal Assessment Tribunal. However, since the assessment orders were not provided to the petitioner before your lordship, my lord, the challenge failed. Writ petitions were filed, attempts were made by the KMC to disconnect water supply, and ultimately, my lord, a writ petition was filed challenging the validity of second proviso to section 179 2D of the Act as the provisions then stood. Along with, my lord, the demands so raised for the period commencing from 84-85 till 99-2000. So, my lord, may I just take your lordship to the relevant provision as the provisions then stood? Kindly take, my lord, for once. है तुम्हारे पास ये भी है कॉपी नहीं है ना my lord, kindly take, my lord, this 179(2) as the provisions then stood.
Yes,
I'm sorry. Kindly take, my lord, clause D of subsection 2 of section 17. Well, the annual valuation, the annual valuation under this chapter may be revised on the expiration of each such period, provided that when annual valuation of any land or building has not been revised on the expiry of any such period, for reasons to be recorded in writing, the previous annual valuation shall continue to remain in force until it is so revised. Now, we were concerned with second proviso, provided further that municipal commissioner may, on the expiry of such period, revise the annual valuation of such land or building at any time. But this at any time, my lord, vested the authority with the power to make assessment even after, say, 10 years, 5 years, 16 years, 20 years. As your lordship will find, the assessment orders for the even 84, 85 till my lord 89, 90, 91, 92 till my lord 94, 95 were made in 99. That is long after the expiration of the period in question, because there was no, my lord, limitation provided for in the statute that within this such period the power has to be exercised.
No, but then you are also relying on Sahujan.
My lord, I am Sahujan.
You are Sahujan.
I am Sahujan. But because my lord,
3 years period, which was
yes. I am Sahujan. Absolutely, my lord. Now, my lord, now what happened, my lord? If your lordship kindly takes the prayers which were made in the writ petition of 2011.
Right.
Kindly take page 96 for once.
Yes.
Well, I will only read two prayers for your lordship's kind consideration.
Yes.
An appropriate writ or order direction do issue directing the second proviso to section 179 2D of the Kolkata Municipal Corporation Act to be ultra vires Article 14 of the Constitution. A writ in the nature of certiorari do issue commanding the respondent authorities to transmit the assessment orders from dated 16 November 1999 for the assessment period 4th quarter 1984-85 up to 3rd quarter 99-90, 4th quarter 1991 to up to 3rd quarter 96-97, 4th quarter 1996 up to 97 up to 4th quarter 1999-2000. So these were the subject matter of challenge. Now, what happened thereafter, when this writ petition was moved, an interim order was passed.
Yes.
Your lordship will find the interim order at page 100. Because, my lord, the
Yes.
bills were, or the demand was challenged in the writ petition. My lord will kindly take from the second paragraph at page 100. So far as the prayer for interim order is concerned, as it is submitted by so and so learned advocate for the petitioner, that according to the calculation of the petitioner, the dues are to the tune of rupees 1,28,34,746, which is disputed by so and so learned senior advocate on instruction from so and so for the KMC. According to the corporation, dues are more than 2 crores. Since according to the petitioner, the dues are to the tune of rupees 1,28,34,746, the petitioners are directed to deposit the said amount with KMC within 14th March. The petitioner is also directed to deposit a further sum of rupees 35 lakhs within 26 March 2012. The authorities of the corporation are restrained from taking any coercive action till 27th March 2012 regarding the dues for the period in question. The amount deposited shall be without prejudice to the rights so and so. So, now payment was made that 1,28 lakhs was paid. But so far as the further direction to make payment of 35 lakhs, that was carried to the Honorable Division Bench by an intra-court appeal. Now, in the appeal, Lordship will find at page 105.
In second volume, then.
Well, I will not trouble your lordship with the entirety of the order passed by the division bench. Kindly take page 107.
Just 1 second.
I'm sorry, madam.
One 107.
107.
Yes.
Kindly take, my lord, the first new sentence at 107, having regard. Having regard to the said legal position, my lord has got that?
Yes, yes. The impugned order.
Input order, so far as the direction for payment of rupees 35 lakhs within stipulated period is not legally sustainable, the same stands set aside and quashed. The appeal is thus allowed, their learned judge will now proceed with the writ petition. Now, this writ petition was heard by an honorable single judge. The honorable single judge, by a judgment and order dated March 12, 2015, was pleased to dismiss the writ petition. That order, your lordship will find at page 108.
Yes.
But I will trouble your lordship with some portion of the order
Yes.
which went against us.
Mhm.
That is at page 112. The new paragraph.
The challenges in the writ petition.
Yes, by reading the order dated April 20, 2007 with the order dated August 31, 2007.
Yes.
I am of the view that the writ petitioners voluntarily and unconditionally gave up the challenge to the vires of the second proviso to section 179 2D of the Calcutta Municipal Corporation Act at the hearing of WP number so and so. The vires of such portion of the said act was not given up as a concession of law as sought to be contended by the learned counsel on behalf of the petitioner. Such is not the recording in the orders passed in the earlier writ petition. In such circumstances, I do not think it would be prudent to allow the writ petitioners to canvass the vires of the second proviso to section 179 2D of the KMC Act afresh after they had unconditionally abandoned and not pressed the challenge to the vires of the said provisions of KMC Act 1981. They refer to the earlier writ petition. The challenge in the present writ petition is directed against the bills appearing at pages so and so, 119 to 11127. Then finally, my lord, this writ petition was dismissed. Your lordship will find the operative part of the order at page 114 to 115. Now, this judgment rendered by the honorable single judge was carried to the division bench. Now, your lordship will find the judgment on order dated April 26, 2018, delivered by the division bench at page 119 of the writ petition. Kindly take from page 128.
Yes.
The power conferred on the municipal commissioner to revise the annual valuation of land or building under section 179(2), second proviso was indeed unlimited in point of time and very wide in its amplitude. Any piece of legislation should be, where unguided or uncanalized power is given to an authority to that extent invalid. Therefore, the power conferred on the commissioner, in my opinion, is indeed so unlimited that it falls foul of Article 14 of the Constitution of India. However, in the Supreme Court cases discussed by me, above similar powers were conferred on the authority. In case of New Delhi Municipal Committee versus LIC 1977 Supreme Court 2134, similar powers conferred on the Municipal Committee under the Punjab Municipal Act to amend the assessment list in all these matters, including the municipal matter. The Supreme Court did not declare the provisions as ultra vires but tried to read down the rigors of the provision by implying the words into offending provision so as to make a provision reasonable. It implied the words within reasonable time after the phrase at any time to make the section workable. We adopt the same procedure. The commissioner can only have power to revise valuation within a reasonable period of time. In the case of Santosh Kumar Shivgonda Patil versus Balasaheb Tukaram Shivale, reported in 2009, 9 SCC 352, the Supreme Court computed the reasonable time in the subject act to be 3 years. Section 573 of the KMC Act, the corporation has the power to recover any sum by initiating a proceeding within 3 years from date in such sum became due and payable. Therefore, on a proper interpretation of the proviso and upon reading it down to save it from unconstitutionality, the period for which the valuation of property can be raised must not be more than 3 years before the date of revising the order, date of the revising order. In those circumstances, this appeal is partly allowed by directing the respondent corporation to make fresh assessment in relation to the period covered by prayer B of the writ petition on the basis of the observations made in the judgment within 8 weeks of the communication of the order, and to raise final bills on the appellant petitioner within a further period of 1 week and realize the same as soon as possible, not later than 4 months from the date of service of this order. This was the order. Now, this order was challenged before the Honorable Supreme Court. Your Lordship may kindly take page 132.
Yes.
Your Lordship will find the special leave petition was dismissed
Yes.
by an order dated 18 January 2019.
Yes.
Well, the corporation didn't stop there.
The review also filed.
Review was also filed.
Yes.
Review, Your Lordship will find at page 145.
145 and 1.
And my lord, Your Lordship will kindly only take the last paragraph at page 145 and the first new paragraph at 146. The operative part of the judgment and order dated 26th April, of which review is sought, observes and directs that the commissioner could only exercise the power to revise the valuation within a reasonable period of time, which is 3 years, following the case of so and so. Reading down section 573 of the KMC Act, and to save it from being declared unconstitutional, the court held that the period for which the valuation of property could be revised could not be more than 3 years before the date of revision order. The grounds sought to be urged in the memorandum review do not say that any error on the face of the record is apparent, or there was any discovery of evidence which by due diligence was not available at the time when the said judgment and order was made by this court, or any other similar grounds. My lord, this was dismissed. Then, my lord, on 3rd May 2024, another SLP was carried against this review order.
Page 153.
Page 153. The Lordship has got that. I need not read that. Now, my lord, what is most important is that while the corporation KMC pursued the remedies available under the law, challenging the division bench order dated, my lord, 26th April 2018, an amendment act was brought about.
Page 161.
Page 161. Your Lordship will find the amendment act
3D clause 1, right?
3D clause 1. Absolutely. Clause 3D, clause II. I'm sorry, II. Because, my lord, II, my lord, these two clause D has been substituted, and II basically restores what was set at naught by the Honorable Division Bench of this Honorable Court. Because may I read II for your Lordship's kind consideration?
Yes.
Notwithstanding anything contained in this act or any judgment, decree, or order to the contrary, the annual valuation of such land or building, where it had already been made or revised beyond such period, the same including realization of property tax on the basis thereof, shall be deemed to be valid, and any outstanding property tax on such revision shall be recoverable. So, my lord, whatever was there in 179 2D, second proviso, my lord, the position of law and the effect of that position of law on the assessments, that effect of position of law on such assessments was restored.
Yes.
And the division bench judgment was set at naught without removing the basis of the judgment. But the test is always whether the basis of the judgment stands removed. If the basis of the judgment doesn't stand removed, and my lord, if the new law seeks to, my lord, nullify the effect of the judgment, then that law is, in my most respectful submission, not sustainable in the scheme of the Constitution and in the scheme of separation of powers. Now, my lord, kindly take for once what is not on record. May I build it up? May I place before your Lordship the statement of object and reasons? Perhaps that is not on record. My lord, perhaps my lord, Mr. Banerjee has not placed that. Build. This is, my lord. I'm sorry. My lord has got that?
Yes.
Oh.
Yes.
Kindly take the statement of object and reasons, which your Lordship will find at page 6 of the bill. kindly take the language used by the legislature. It is considered necessary and expedient to amend the Kolkata Municipal Corporation Act inter alia for the purposes of II, if your lordship kindly takes, giving overriding power for making periodic assessment of any land or building within the stipulated period after expiration of the earlier period of assessment, and giving effect of such periodic assessment retrospectively where it has not been revised after immediate expiration of earlier period of assessment, and for validation of such periodic assessment which has already been made or revised after stipulated period, including realization of property tax. Well, it is clearly offending the law settled by this division bench of this honorable court, and also which was affirmed by the honorable Supreme Court not once but twice. And my lord, this is where, my lord, I tell you, lordship, my lord, this is where I would like to cite one authority which has been cited by Mr. Banerjee, but I would like to cite it in a slight more detail. That is, my lord, New Shrock. Perhaps, my lord, Mr. Banerjee has handed up the compilation subject to correction, but it is there with us also. New Shrock, which is 1970 volume, it's there. Oh,
I think it's number 10 here, if I'm not wrong.
volume 2 SCC 280. I think New Shrock has been cited, perhaps subject to correction, my lord.
Yes.
But the facts of the case,
Yes.
well, may I take your lordship to directly to paragraph 2 and 3? Rather from 1. Hearing the validity as well as interpretation of some of the provisions of the Bombay Provincial Municipal Corporation Act as amended from time to time by Gujarat State comes up for consideration. In these proceedings, some of the textile mills of Ahmedabad are ranged against the state of Gujarat as well as the municipal corporation of the city of Ahmedabad. They are seeking to get refund of some amount paid as property tax paid by them, which amount according to them were illegally collected from them. In order to understand the controversies involved in this proceeding, it is best to set out the course of events leading up to these proceedings. Various textile mills which are involved in these cases will hereafter be referred to as companies. These companies own immovable properties consisting of lands and buildings in the city of Ahmedabad. The Municipal Corporation of City of Ahmedabad, in the purported exercise of its power under the Act and the rules made frame thereunder, assessed immovable properties of the companies of to property tax for assessment years 64-65 and 65-66. Those assessments were done on the basis of method popularly known as flat rate method. According to that method, in valuing lands, the value of plants and machinery were also taken into consideration. The buildings were assessed on the basis of their floor area. Those assessments were challenged by means of writ petitions under Article 226 and 227 before the High Court of Gujarat by the companies. Those petitions were dismissed by the High Court. The aggrieved companies thereafter brought up the matters in appeal to this court. During the pendency of these appeals, the corporation proceeded to assess those companies as well as others to property tax for assessment year 66-67. Those assessments were challenged before this court by some of the companies by means of writ petitions under Article 32 of the Constitution. Meanwhile, on the strength of the assessment made for assessment year 64-65, 65-66, the corporation initiated proceedings for recovery of taxes due under those assessments. Some of the companies paid the tax assessed, but some others, including Manek Chowk, spinning and weaving mills, did not pay the tax levied on them. Hence, the officers of the corporation resorted to attachment of their properties. At that stage, those companies challenged the validity of those attachment proceedings before the High Court of Gujarat under Article 226 of the Constitution. Those writ petitions were dismissed. The High Court also refused to grant certificates under Article 133(1). But the concerned companies appealed to this court after opening special leave from this court. In those appeals, those companies prayed for an interim stay of recovery proceedings. This court declined to stay the proceedings in view of the undertaking given on behalf of the corporation to refund the tax collected within a month from the date of judgment of this court if those companies succeeded in the writ petitions before this court. By its judgment dated February 21, 1967, this court struck down the rules framed under the Act permitting the corporation to value the lands and buildings on the flat rate method. The court opined that it was not permissible for the corporation to value the premises on the basis of the floor area, nor could it take into consideration the value of plant and machinery in determining the rateable value of the lands and buildings. The decision is reported, and in view of that conclusion, the assessments impugned in the writ petition were set aside. The judgment of this court dealt with the validity of assessment for the year 66-67. But at the time when the judgment was delivered, the appeals by some of the companies in respect of the assessment made for the year 64-65 and 65-66 were still pending in this court. On March 30, 1968, the state of Gujarat brought into force an act entitled Bombay Provincial Municipal Corporation Gujarat Amendment Act 68. The appeals filed by the companies in this court came up for hearing on April 15, 1968. This court allowed those appeals following its decision in New Manekchok spinning and weaving mills and others. When those appeals were heard, neither the state of Gujarat nor the corporation brought to the notice of this court the provisions of the amending act. Pausing here for a moment, when the SLP against the review petition was being heard, already the act was enacted and the corporation did not bring it to the notice of the Honorable Supreme Court that they have amended the act. Rather proceeded with the litigation. After the judgment of this court on those appeals, the concerned companies called upon the corporation to refund amounts illegally collected from them as property taxes for the assessment year 64, 65, 65, 66. The corporation did not respond to the demands made by those companies, hence they again moved High Court of Gujarat under 226, seeking writ of mandamus against the corporation and its officers, directing them to refund the amounts illegally collected from them, and for a direction that Section 152A of the Act, newly introduced by the amending Act, is ultra vires the Constitution. The High Court of Gujarat allowed those petitions. That court did not go into the vires of Section 152 capital A, but on a construction of that provision, it came to a conclusion that the said provision did not permit the corporation to withhold the amounts illegally collected. The appeals which we are concerned were filed by the state of Gujarat and the corporation against the decision. During pendency of those appeals, the corporation moved to stay. Then another, kindly skip over. Kindly take my lord thereafter on or about December 23, 1969. My lord has got that?
Yes.
On or about December 23, 1969, the governor of Gujarat promulgated an ordinance under Article 213 of the Constitution entitled the Bombay Provincial Municipal Corporation Gujarat Amendment and Validating Provisions Ordinance. This ordinance will thereafter be referred to as the ordinance. That ordinance came into effect effectively. By means of that ordinance, a new subsection, namely subsection 3, was introduced in Section 152A. The effect of insertion of subsection 3 of section 152A is to authorize the corporation and its officers to refuse to refund the amount of tax illegally collected despite orders of this court as well as the Gujarat High Court till the assessment or reassessment of property tax is made in accordance with the provisions of the Act as amended. But under its provisions, the corporation is required to pay interest at 6% on the amount ultimately found to be liable to be refunded. In these petitions under consideration, the validity of the aforementioned provision is challenged. Then they consider the provisions contained in the different in section 152A, and then kindly take paragraph 6, where this subsection 3 has been set out. that the corporation would be entitled to withhold the refund of amount already collected or recovered in respect of any property taxes to which subsection 1 applies till assessment or reassessment of such property taxes is made. I mean, kindly takes 7, paragraph 7. This is a strange provision. Prima facie, that provision appears to be to command the corporation to refuse the refund, the amount illegally collected despite the orders of this court and the High Court. The state of Gujarat was not well advised in introducing this provision. That provision attempts to make a direct inroad into the judicial powers of the state. The legislatures under our constitution have within the prescribed limits powers to make laws prospectively as well as retrospectively. By exercise of those powers, the legislature can remove the basis of the decision rendered by a competent court, thereby rendering that decision ineffective. But no legislature in this country has power to ask the instrumentalities of the state to disobey or disregard the decision given by courts. The limits of the power of legislatures to interfere with the directions issued by the court were considered by several decisions of this court. In Sri Prithvi Cotton Mills versus Broch Borough, our present Chief Justice speaking for the Constitution bench, Prithvi Cotton Mills has been quoted. I don't want to trouble your lordship because it has been placed. Mahalchand Shetia is also quoted. Then, my lord, Janpat Sava is quoted. And finally, at paragraph 8, the Supreme Court held that we are clearly of the opinion that subsection 3 of section 152A introduced by the ordinance is repugnant to our constitution. That apart, the said provision authorizes the corporation to retain the amounts illegally collected and treat them as loans, as an authority to collect forced loans. Such conferment of power is impossible in our constitution. So this is the law which has been laid down by the Honorable Supreme Court in, my lord, New Shrock Spinning and Weaving Mills. And, my lord, your lordship will find the facts are somewhat opposite to the facts of this case. Now, the next authority which I would like to cite is Indian Aluminium, which was not cited by Mr. Banerjee. Kindly take 1996 7 SCC 637. Initially, a levy of surcharge on electricity duty was challenged. Your lordship will find at paragraph 3. Murder has got that? Paragraph 3, placitum F. In the meantime, the levy of surcharge was withdrawn. Well, on 27/1988, a division bench of High Court in Chakola Spinning and Weaving Mills held that levy of surcharge is in substance, is a compulsory exaction intended to enrich the coffers of the state and in effect partakes the character of a tax on electricity. The government acting as a delegate under the Kerala Essential Articles Control Act is not competent to impose any tax. A writ of mandamus was issued directing refund of surcharge collected from those petitioners before the High Court. The Kerala State Electricity Supply, Kerala State Electricity Board license area surcharge order was declared ultra vires, the power of the state government. The said judgment was confirmed by this court, dismissing the special leave petitions in limine. At this stage, it may be necessary to mention that Essential Articles Control Act 1963 was amended and Act 13 of 88 was enacted. It is also relevant to note that
Yes.
I'm sorry, madam. I was placing paragraph 3.
Yes.
Where the surcharge was declared ultra vires by the Kerala High Court and the SLP was dismissed by the Supreme Court. And then, my lord, the Kerala State Legislature amended the Act and introduced and amended the Act of 88. Amended an Act of 88 was enacted. And it is also relevant to note that exercising the power under entry 53 of list 2, The Kerala State Legislature had enacted the Kerala Electricity Duty Act 63, and the rules were made to levy electricity duty at varying rates. The orders were passed by this court on 13/4/89, dismissing the special petition. So and so, the governor of Kerala, exercising the power under Article 213 of the Constitution, issued an ordinance called the Kerala Electricity Surcharge Levy and Collection Ordinance 89, which later on became an enactment. Under the enactment, the appellants are liable to pay 2.5 paisa per unit of electrical energy supplied. The appellants challenged the same by filing a writ petition. The High Court upheld the validity of the act and the order, thus the appeals by special leaves. I'm going to kindly now take paragraph 31, which is at page 652. Well, what I'm on in this case is that kindly take, my lord, paragraph 56, 31, 35, it is there. 56, the law has been summarized by the Supreme Court. And this, my lord, paragraph 56 is quoted in almost all the judgments. Kindly take, my lord. But the tests have been laid down. From the resume of the above decisions, the following principles would emerge. The Miller kindly take subparagraph 6. The court, therefore, needs to carefully scan the law to find out A, whether the vice pointed out by the court and invalidity suffered by previous law is cured, complying with the legal and constitutional requirements, whether the legislature has competence to validate the law, whether such validation is consistent with the rights guaranteed in Part 3 of the Constitution. The court does not have the power to validate an invalid law or legalize impost of tax illegally made or collected, or to remove the norm of invalidation or provide a remedy. These are not judicial functions but exclusive province of the legislature. Therefore, they are not encroachment on judicial power. In exercising legislative power, the legislature, by mere declaration, without anything more, cannot directly overrule, revise, or override a judicial decision. It can render a judicial decision ineffective by enacting a valid law on the topic within its legislative field, fundamentally altering or changing its character retrospectively. The changed or altered conditions are such that the previous decision would not have been rendered by the court if those conditions had existed at the time of declaring the law as invalid. It is so also empowered to give effect to the retrospective legislation with a deeming date or with a effect from a particular date. The legislature can change the character of the tax or duty from impermissible to permissible tax, but the tax or levy should answer such character, and the legislature is competent to recover the invalid tax, invalidating such a tax, on removing the invalid base for recovery from the subject, or render the recovery from state ineffectual. It is incompetent for the legislature to enact the law with retrospective effect and authorize its agencies to levy and collect the tax on that basis, make the imposition of levy collected and recovery of tax made valid, notwithstanding the declaration of by the court or directions given for recovery thereof. The consistent thread that runs through all the decisions of this court is that the legislature cannot directly overrule the decision or make a direction as not binding on it, but has the power to make the decision ineffective by removing the base on which the decision was rendered, consistent with the law of the Constitution, and the legislature must have competence to do the same. So, pausing here for a moment, kindly take the proviso, second proviso to section 179 2D as the provisions then stood, and the amendment made to, section 179 2D, which has been rewritten. Kindly, my lord, the second proviso said, provided that the municipal commissioner, if your lordship has got that,
Yes.
the municipal commissioner, second proviso, on expiry of such period, revise the annual valuation of such land or building at any time, and such revised valuation shall take effect from the beginning of the quarter from which annual valuation would have been revised under this clause. But the division bench of the High Court held that at any time would mean 3 years.
Reasonable.
3 years. But the now this 179 2D as it now stands, kindly take 179 2D, which is there at page 160, 162. If your lordship kindly compares 179 2D II, your lordship will find now it is provided where it had already been made or revised beyond such period, the same including realization of property tax on the basis thereof shall be deemed to be.
Where are you reading?
I am taking a lordship to the 179 2D. This is 162 of our petition. I am trying to compare second proviso of section 179 2D, which has been read down by this honorable court, and also 179 2D II, which now is the relevant provision, the validity of which I have now challenged before the lordship. The comparison would be necessary. If we compare the both, compare one second proviso of section 179 2D as the provision stood prior to during the relevant period of time. In fact, these two provisos were deleted from the statute book from in the year 2007. But the assessments in questions were made in 1999. So these provisos were very much in operation. If we compare, may I just take your lordship once more?
Yes.
This is all about the interpretation,
Yes.
because my test is very clear. If the basis stands removed, the law is valid. The basis doesn't stand removed, and if it is merely a direct nullification of the judgment rendered by the court, competent court, then, my lord, the law would have to be declared as invalid. Provided further, my lord, kindly, I beseech your lordship, further that the municipal commissioner may, on the expiry of such period, revise the annual valuation of such land or building at any time. So, my lord, at any time was read down to be a reasonable time, which would be 3 years. And such revised valuation, which would mean, in my case, it is fourth quarter of 1984-85 till, my lord, the fourth quarter of
2000.
99 fourth quarter of 99-2000. So, my lord, when the assessments are made, my lord, in the month of November 1999, my lord, no assessment could have been made for the period that is fourth quarter of 1984-85 till, my lord, fourth quarter of 95-96. Under no circumstance this could have been made if, my lord, the law as laid down by this honorable court is allowed to stand. No, my lord, now kindly take what this amendment has done. The amendment says, now, notwithstanding anything contained in this act or any judgment, decree or order to the contrary, the annual valuation of such land or building, then II, where it had already been remade or revised beyond such period. So it takes into account all the assessments which were made beyond the period, as specified, my lord, in I. We have to read I along with II. I says that may be revised at any time not beyond 6 years from the date of expiration of such period, and such valuation shall take effect from the beginning of the quarter from which the annual valuation could have been revised. Again, my lord, subject to lordship's kind consideration, when this honorable court has held, it has to be 3 years. My lord, it cannot be beyond 6 years. 6 years. 6 years. Now, my lord, now having regard to the clause subclause I of clause D, we have to read clause II, subclause II. II says where it had already been made or revised beyond such period, which would mean the period as in my lord I, that is 6 years, the same including realization of property tax on the basis thereof shall be deemed to be valid, and any outstanding property tax on such revision shall be recoverable. Which basically, my lord, restores the position, restores the my lord, second proviso of my lord to section 179 2D, which was there till 2007. My lord, it does not say, my lord, if I and II are read, I offends, my lord, 3 years that, and when II it is read, my lord, it basically gives them, my lord, what should I say, my lord, absolutely a free hand. They can very well enforce an assessment made in the year 99-2000 for the period 1980-81 and enforce the demand, and if any demand has been raised and amounts have been collected, they can retain or withhold that amount so collected or recovered. But this is complete second proviso. My case before lordship is very simple. Now when the division bench has held, which has been upheld by the Supreme Court, not my lord, challenges were made on 2 occasions, failed. First, my lord, SLP against the main judgment. Second, SLP against the review judgment. Even, my lord, when the, my lord, the second SLP came before the Honorable Supreme Court, they had already enacted this law. They did not enforce the law so far as the petitioner is concerned. What they did is very interesting. Enforce the law, they pursued with the, my lord, the judicial proceedings. Then, my lord, when everything failed, when we issued a legal notice upon this corporation, kindly take page 154 of the petition. This is subsequent to, my lord, dismissal of review petition as SLP against the review order rejecting review. We refer to the entire genesis of the case, and then finally we say we at paragraph 12 at page 157 we say that we are entitled to refund because we had already paid 1 crore 24 lakhs plus, my lord, some amounts, my lord, which are to be decided. Obviously, my lord, direction was for assessment, so it is to be decided what is to be refunded. Kindly take paragraph 11 onwards at page 157.
Yes.
Please appreciate that our clients have made payment of property tax far in excess of the legitimate claim of KMC, and our clients are entitled to substantial refund. Withholding such refund by KMC has been causing great prejudice to our clients. In the circumstances and the instructions from our clients, we now finally call upon you to forthwith act in terms of the said judgment and order dated 26th April 2018 by the division bench and make fresh assessment of property tax in relation to the period covered under prayer B of the writ petition, that is 4th quarter 84-85 to, my lord, 4th quarter 99-2000. Please appreciate that you have failed to act in terms of the said judgment and order dated 26th April 2018 passed by the division bench of Calcutta High Court for more than 6 years, initially on the ground of pendency of review application before the Honorable Calcutta High Court, and therefore on the ground of pendency of special leave petitions before the Honorable Supreme Court. Since both the special leave petitions of KMC have been dismissed and the said judgment and order dated 26th April 2018 passed by the division bench of Calcutta High Court has achieved finality, the KMC is now bound and obliged to give effect to the judgment and order forthwith. In spite of aforesaid, he failed to act in terms of the said judgment and order dated 26th April 2018 passed by the division bench of Calcutta High Court within 4 weeks from the date of receipt of this notice. Consequently, a refund to our clients the excess property tax realized from them, then our clients would be constrained to initiate appropriate proceedings. Now, Miller, comes the reply. But this is the cause of action, immediate cause of action. This is page 158. Subject to a request for giving effect to the order of Honorable Division Bench, High Court Calcutta passed in APO so-and-so in the matter of Sauja and so-and-so. Your letter addressed to Municipal Commissioner regarding premises number so-and-so. This is to bring to your kind attention to the fact that section 179(2) of the Kolkata Municipal Corporation Act has been amended as follows. Now, my lord, they refer to the amendment made by the Amendment Act 2022. Therefore, the demands that emanate from the annual valuation of 21 lakhs so and so with effect from fourth quarter 1984-85, rupees 28 lakhs so and so with effect from fourth quarter 1990-91, and rupees 32 lakhs 97,000 so and so for with effect from fourth quarter 96-97 stand upheld, as the same has been validated in terms of the amended section 179 2D of the Kolkata Municipal Corporation Act. As on date, an amount of rupees 11 crore 27 lakhs 669, including interest, is 8 crore 22 lakhs 14,498, and penalties again 39 lakhs. Deposit suspense so and so is lying as outstanding property tax. You are requested to pay the outstanding as soon as possible, failing which the corporation will be constrained to take tax recovery steps as per law. So this is for the first time in the on 23rd July 2024, the petitioner is being informed that everything has been validated in terms of the amendment made to the section 179(2)(d). So, my lord, my submission would be, my lord, 179(2)(d) as amended by the KMC Act, KMC Amendment Act 2022, my lord, does not remove the basis of the judgment rendered by this court, division bench of this court. Rather, my lord, it restores or revives whatever was set at naught by the honorable division bench. My lord, it is a direct inroad into, my lord, the judicial functions of the state. And, my lord, it in fact, my lord, it is, my lord, even the courts have been taken for a ride. When the SLP was pending before the Honorable Supreme Court regarding the review order, the act was in place. They did not even cite this act as a defense, so far as, my lord, the payment is, the assessment is to be made. Now, my lord, one more authority just to end my submissions, my lord. Kindly take for once. This has again been placed, but this is K. Shamsundar, 2011 8 SCC 737, paragraph 62, 60, 62, 65. 8 SCC 737.
Madam, what is the number?
My lord, I do not find it here. It was not cited.
No, 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 no.
Not cited.
My lord,
yes.
My lord, I will place just some of, I am not placing paragraph 60 because it refers to Broach Borough, but I will place paragraph 61, which, my lord, summarizes the law laid down in S.R. Bhagwat, my lord, which was left for me by Mr. Banerjee. Kindly take, my lord, paragraph 61.
Yes.
In S.R. Bhagwat versus State of Mysore, a similar issue was considered by this court while considering the provisions of Karnataka State Civil Services Regulation of Promotion, Pay and Pension Act 73. In that case, the provisions of that act disentitled deemed promotees to areas for period prior to actual promotion. These provisions were held to be not applicable where directions of competent court against the state had become final. The court observed that any action to take away the power of judicial decision shall be ultra vires the powers of state legislature, as it encroached upon the judicial review and tried to overrule the judicial decision binding between the parties. The binding judicial pronouncement between the parties cannot be made ineffective with the aid of any legislative power by enacting a provision which is in substance overrules such a judgment, and not in the realm of legislative enactment, which displaces the basis or foundation of the judgment and uniformly applies to a class of persons concerned with the entire subject sought to be covered by such an enactment. Then, my lord, Kaveri water dispute has been referred to. I will not trouble your lordship. That is 93, I believe. Yes, 93 supplementary. Then, my lord, Madan Mohan Pathak, that is the LIC case, has been referred to at paragraph 63. Manjula Bhasini has been referred also, paragraph 65. In view of the above, the law and the issue can be summarized to the effect that a judicial pronouncement of a competent court cannot be annulled by the legislature in exercise of its legislative powers for any reason whatsoever. The legislature, in order to revalidate the law, can reframe the conditions existing prior to the judgment, on the basis of which certain statutory provisions had been declared ultra vires and unconstitutional. But there is no reframing in this case. This is merely, my lord, reviving or restoring, resurrecting the provisions which have been nullified by this court. And the last one would be, my lord, that is 2019, which, my lord, I believe Mr. Banerjee has cited. Paragraph 40, 2019, 13 SCC 185. This is MCI versus State of Kerala. Paragraphs 43, 44, and 45. I don't know, my lord, whether it has been cited, I don't know, but it was there in the list. Kindly take, my lord, paragraph 43 onwards. It is apparent, my lord has got that, paragraph 43, sorry.
Para 43, right?
Yes. It is apparent from the order passed by this court as well as the High Court of Kerala that receiving online applications was mandatory and it was laid down in the judgment for ensuring fair process of admissions, transparency as well as identities of the applicants. The condition was the outcome of the judgment on power of judicial review passed by Kerala High Court and affirmed by this court also. Thus, the very same judgment is sought to be nullified by the impugned ordinance by making a provision. Wherever it's very strange, wherever I see that there is some kind of nullifying effect is sought to be ordinance. 213 for state, 123 for union. Interestingly, the numbers are 213 and 123. The condition was the outcome of the judgment on the power of judicial review passed by Kerala High Court and affirmed by this court. And thus the very same judgment is sought to be nullified by the impugned ordinance by making a provision to the contrary. Admissions as per ordinance are to be regularized, dehost the mode of submitting application. It is not removing the defect in any existing law. The ordinance has clearly annulled a judgment of the court which was laid down in order to ensure fair procedure. We have anxiously read the entire impugned ordinance, and perusal thereof indicates that it is blatant attempt of regularization of admissions made, which were declared to be invalid not only by High Court of Kerala but by this court after this court had dealt with the order dated 14/11/2016 passed by ASC after hearing the matter for several days, and the court had passed a reasoned order. While dismissing or disposing of the matter, this court directed 30 students who were illegally deprived of their admission to be admitted in the next academic session, 2017-2018. It was clearly not a dismissal of case in limine but a reasoned order, but in the writ petitions filed by the colleges and the others, the validity and legality of the order dated 14/11/2016 was questioned. However, this court has upheld the same. We also note the voluminous records were filed by this court by both the medical colleges. The students were also heard when the decision was rendered. Thereafter, several petitions were filed which were dismissed by the court. Thus, when this court has upheld the order dated 14/11/2016 on the ground of illegality and irregularities and not following due procedures, such admissions could not have been regularized at all. In case such a power of covering up illegal action is given to the state government in individual cases of two colleges, the day is not far off when every judgment can be annulled. It is clear that in the instant case, the state government has exceeded its power and entrenched upon the field reserved for the judiciary. It could not have nullified the judgment. The online procedure was laid down by the judgment. The provision of any existing law framed by the legislation has not been changed by the state government by the impugned ordinance, but the illegalities found in the admission were sought to be got rid of. What was laid down in the judgment for ensuring the fair procedure, which was required to be followed, was sought to be undone. It was nothing but the whole impermissible act of the state government of sitting over the judgment and it could not have promulgated the ordinance setting at naught the effect of the judgment. It was also apparent what the state government has done by way of impugned ordinance is not only impermissible and beyond legislative competence, but it has also the effect of perpetuating illegality and arbitrariness committed by the colleges. So, well, this is it. Then it goes on to separation of powers. So, well, I summarize, I conclude by making these submissions. But obviously, my lord, I would reserve my right to give reply after hearing Mr. Kaur. My lord, the KMC Bill 20, Amendment Bill 2022, my lord, in a brazen manner, says that we are overriding and validating. The expression used is overriding and validating. Now, what they are validating? They are validating all the assessments made beyond a reasonable period of time as indicated or as laid down by the Honorable Division Bench of this Honorable Court. The expression reasonable period of time has been defined, judicially defined, to mean 3 years. So 179 2DI says 6 years. A. We are more affected by 179 2DII because 179 2DII restores and revives, rather than it pulls, it's a kind of, it's an exhumation process. It's a kind of exhumation process that, the orders which were allowed to rest in peace, the assessment orders, those assessment orders are now pulled out of their graves. And now, we are to face those assessment orders and also bear the brunt of the tax which has been sought to be imposed by those assessment orders. All those assessment orders were indisputably passed on 16th November 1999. The period involved, I already indicated, it involves fourth quarter of 84-85 to fourth quarter of 1999-2000. So, my lord, in effect, my lord, the assessments for the period till 95-96, they can do. I'm not saying that they cannot do. They can do for the period commencing from first quarter 96, first quarter 96-97, 96-97 till, my lord, 99-2000, because, my lord, they initiated proceedings for that. My lord, but they cannot make assessments, or they cannot enforce any assessments illegally made for a period prior to, my lord, first quarter of 96-97. And, my lord, if both the provisions are compared, my lord, I put the question to myself with all humility, my lord, the basis is not removed. It is only nullifying the effect. My lord, because the basis has not been identified at all. What was the defect? Defect was that you have not defined. You have not defined any time. And now, what you have tried to define, you have defined that 3 years have been made 6 years. And, my lord, not only that, my lord, now you are also trying to reinforce the assessments which were already made. And collections were made by you without following, obviously, the rule of law. So, my lord, the interest, penalty, etc., the bills have been set aside by this Honorable Court. Now, my lord, your lordship will find from the communication, the interest is about 8 crores. The penalty is about 37 or 38 lakhs. Now, my lord, so, my lord, they are not only enforcing the demands, they are also levying interest thereon and also imposing a penalty when, my lord, I was protected by the order of this Honorable Court. And they do not even bring to the notice of the Honorable Supreme Court, when the Supreme Court was hearing the SLP, that yes, we have already made an enactment. Because, my lord, they were afraid. They knew what would be the consequence. But these are my respectful submissions before lordship. My lord, once Mr. Kaur concludes, my lord, obviously.
Then you can, yes.
And, my lord, I will file my notes at the end of the hearing.
Yes,
subject.
both the parties.
Yes, my lord, because, my lord, once if I don't
If the arguments were concluded, then you can file your written on
May I start on Wednesday?
3:30.
Not because of 3:30, but just thinking what I have not heard the complete submission of Mr. Majumdar. So
More or less is the same. He basically is saying that the amendment which has been brought in is in
He has made a submission on the revalidation point.
revalidation.
That argument he has advanced. I got it that he's putting a lot of stress on the revalidation. If your lordship permits, otherwise, I'm in your lordship's. Start on Wednesday or
Tomorrow? No.
tomorrow, 2 o'clock, there's a matter fixed. Taking 1 day's indulgence.
All right. Arguments heard. Let it be listed for further arguments on Wednesday at 2 o'clock. Because I also want to wrap it up so that.
Yes, certainly, madam.
But once the continuity is lost, it's
That's difficult. Then I
that
also.
is why I tried to not repeat whatever I tried, my lord.
Yes, absolutely. It was very helpful.
Because my lord,
you didn't repeat at all.
my lord, when you are a second fiddle, when I'm putting this, then my lord, it is very difficult because my lord, whatever the opening submissions have been made, it has to be in sync with those submissions.
Absolutely.
Grateful, my
So
lord.
today we have the 3:30. So
Today is 3:30, my lord.
that's what.
So, my lord, don't post any matter at 3:30 on any day. Normally on Friday. Friday, my lord.
Fridays even I. That's the only indulgence which I take.
My lord, only one thing, my lord, we have already submitted our notes along with those compilations. After Mr. Kaur makes the submission,
yes, you
if
can.
there is any.
Yes, sure.
But my lord, I would like to give a reply.
Yes, absolutely. Absolutely. But we'll try to.
We'll try.
How much?
As short as
My lord,
possible.
That you're
Wednesday,
always.
my lord, Wednesday, my lord, lordship may kindly give me Friday, Thursday. If your lordship is hearing it on day to day.
I might take the whole.
All right.
Second up, Thursday, my lord, give us, my lord, 30 minutes or so, my lord. We'll wrap it up.
The rest of the matters.